Let it appear, my lord, this is one writ petition is one of 2004 and one is of 2023.
September monthly list.
Monthly list. My lord, kindly make it have any day supplementary. My lord, kindly appreciate, my lord, this, my lord, your lordship heard twice these matters.
That's all right, but
Kindly, my lord, I will not take much more.
no,
Because this is a settled principal act and settled by your lordship in another judgment. So, my lord, kindly make it have any day subject to your convenient to your lordship in the supplementary list. Any day. Any day. Kindly, my lord, kindly. Before vacation, your lordship determined after come up after vacation. Any day in the supplementary list.
September.
18th September.
Motion or hearing?
Hearing. Because,
Hearing?
so, my lord, let it be under the motion. Because I tell you, lordship.
If affidavits are there, I will not.
No, no, kindly appreciate, my lord. This is the 2000, your lordship heard substantially, my lord. Since they raised a point that it has to be served upon the...
All right. But if it is hearing, then I cannot take up like this. I cannot.
My lord, we are the worst. So kindly appreciate, my lord.
Sir, there, I know, but...
The 17th April, my lord, one matter was before lordship, then lordship asked me to get it assigned. Then, my lord, both the matter assigned to your lordship.
But hearing matter, sir, I cannot take up like that. Then you come on 2nd August, which is a Saturday. We are open.
We will come. We will come. Kindly make it on 2nd August. I serve notice, we will come.
Who are the other side?
My lord, Chandriya.
Come here.
My lord, my learned friend, junior friend is...
Mr. Shubhankar Chakraborty will be not available on 2nd August. Due to he has some...
No, this is the whole problem. They are taking advantage of the situation of the court.
But he will be in a receiver visit.
Let it be on 2nd August, my lord. Let me argue the matter. In the process, they are taking advantage of the court view.
Come on 2nd August.
Yes.
Come on 2nd August. Let's see.
Yes, 2nd August. Obliged to lords.
Kindly any day except 2nd August. He will be not available on 2nd August.
Let us see. Then you pray for adjournment or what to do. I do not know. Hearing matter, I cannot like that.
Because all the time matter has been adjourned at their instance.
But hearing matter, Mr. Pan, very difficult to reach.
I will cut short the matter, my lord.
Maybe, but several other hearing matters are there. 2nd August, I have already fixed another hearing matter.
2024.
2nd August, I have fixed another hearing matter.
Yes.
And this hearing matter. Very well.
My lord,
or else if you wish to argue after that, Saturday. Hearing matter, Saturday. I will have no difficulty.
We will come.
Hearing matter, if you have any urgency, we will take up on Saturday, some Saturdays.
May I permitted to mention one urgent matter, my lord, education matter under group 2.
What is the urgency that it cannot wait till tomorrow?
Petitioners, my lord, intend to appear at the counselling which is to be held on 1st August.
এই বেঞ্চটা কবে অবধি আছে আমার কাছে অ্যাসাইন্ড ভট্টাচার্য সাহেবের
4 তারিখের আগে পর্যন্ত 7 তারিখ
দুটো আমার একটু দেখান না নোটিশটা এই যে ছাপা আছে তো লিস্টে কোথায় সেটা
up to 1st August, 2nd August.
21 July to 2nd August.
My lord, the 8th counselling is fixed on 1st August. My lord, my learned friend is appearing for the School Service Commission. My lord, what happened, my lord,
it is fixed on 1st August.
Counselling fixed on 1st August.
1st of August, but this is actually a hearing matter. If the direction was given. So
no, let me, what?
Affidavit direction is there.
Yes.
You come up with an interlocutory application.
Yes, I have
filed an application.
Today I being affirmed and to be filed.
So you first affirm and then mention.
No, my lord, I tell you, lord,
sir, without number, I will not enlist.
Applications, my lord, in other way. My lord, what happened, my lord, in this?
I will not take up that hearing direction for affidavit.
My lord, his lordship.
Mr. Counsel, sir, very short question. Has affidavit been directed on the writ petition?
There is a
Opposition
direction-
reply,
There was a direction.
right.
His
So
lordship,
I will take up, if you take up an application, which will be an interlocutory application, I will take up, direct it to appear before first as an application. Matter end. You come up with an application, mention with the number, that I will take up. But I will not allow this hearing with petition to be taken up.
I get to tell us.
If they don't serve, it will not be taken up. Matter as plain as that. Serve them and give him Dr. Patra notice. While you will be mentioning, after getting the number, you give him a notice.
Copy of the application.
You come tomorrow morning, mention the app with the application. Application number you mention tomorrow morning.
I was mentioning one matter for the purpose of the release. This is a presentation form. It was wrongly emailed and mentioned as group 6 matter. It will be group 2 library matter. I mentioned before the concern
To be mentioned.
to be mentioned tomorrow.
My lord, may I permit to mention
To
matter?
be mentioned tomorrow.
My lord, may I permit to mention one matter
আজকে
regarding?
কি ইয়ে আসেনি আমাদের দিদিমণি আসেনি ওই এসিও দিদিমণি আসেননি না ভালো ঠিক আছে তাতে অসুবিধা নেই আমার আর ইয়ে ঠিক আছে
My lord,
আপনাকে দেখিয়ে নেবেন আমার প্রসিডিওর গুলো
may I permit to mention one matter, my lord? Gratuity matter. It's pending from last 2023.
হাউ মেনি
2 matters.
give the slip it will appear in due course you know my orders are there gratuity for interest
No, my part gratuity has been paid and the part gratuity has not yet been paid.
not yet been paid
No.
give it will appear in due course নিয়ে রাখুন অমি বাবু এগুলো রেখে দিন মোশন সার্ভিস হিসেবে আসবে
My lord, may I be permitted to mention one case? Appointment of Asha Kurmi. The matter was heard on 6th March 2025. Report was called for from the state authority. Until then, it is not in the list.
it will appear under the heading motion service September 17
My lord, may
motion service give you sleep
I be permitted? My lord,
where is your sleep motion service September
similar
17
counseling matter in the 8th phase of counseling, upper primary selection process, 2 motion pending before Justice, Honorable Justice Shougata Bhattacharya. It is the first time there is no.
what is the urgency it cannot wait till tomorrow
Yes, my lord, 8th phase of counseling, date fixed on 1st of August 2025. My lord, I am seeking that participate in that counseling. That is the cause of action.
why you are seeking why you have not participated earlier
My lord, I was working in the 9-10 level in the school. My lord, entire panel has been cancelled by the honorable order passed by the honorable Supreme Court in Boishaki Bhattacharya Chatterjee's judgment. My lord, we are. My lord, I am within the zone of consideration. My name is appeared as an main panel. My lord, I am the zone of 14,058 candidate. I have been called for counseling. My lord, in the month of December by the authority, but that time I was working in 9-10 level. But I was in hope that something will be there in the.
nothing
My lord, that matter is pending. My lord, similar order. My lord, honorable coordinate bench.
Commissioner was absent for the first phase counseling.
My lord, similar.
oh, he was absent
Yes, my lord, similar order.
The rule does not allow absentee candidates to come back.
matter and
Similar,
you argue on that
similar
day.
order. My lord, similar order passed by the honorable coordinate bench.
matter
Justice Shougata Bhattacharya, similar order.
well, here the candidate was absent
Yes, appear. My lord, that is.
no here the candidate was absent
Yes, similar issue. My lord, 7th phase of
if the rule is there then
Yes,
I may not pass this
Yes, my lord, similar order passed by
No,
Justice.
similar is all right, but if he shows that the rule is there, absentee candidate cannot be allowed, I will not allow.
My lord, I have the immunity. My lord, as per Supreme Court, there is an order of justice.
If you are an absentee candidate, what immunity?
My lord, just when the honorable Supreme Court passed an order, honorable Supreme Court.
Does it say that the absentee candidate will be there?
Not, but if there is an observation of the Supreme Court, if the candidate is working in the previous school, they should be immediately reinstated or even.
All right, I will see to it.
My lord, similar.
I will see to it. Doesn't similar to me. I will
Seventh
apply.
phase of counseling, when
Yes,
seventh phase of
if the
counseling,
rule says that absentee candidate will not be allowed, it will not be allowed.
my lord, let the matter be appear.
Yes, it will appear.
Lordship.
কোথায়? Where is your? এটা
Yes,
ফেরত
yes.
দিয়ে দিন এখন।
Yes.
Without notice, my learned friend is mentioning at least.
My lord,
six
that matter, previous notice was given, I will serve another notice, my lord, I will
So
serve,
why you are not mentioning on notice?
my lord,
Why you are not
My lord,
mentioning?
I shall, tomorrow, I,
No, but why you are not mentioning on
my lord,
notice?
since Mr. Dr. Patru is appearing, my lord,
He is not appearing for your matter.
no, entire matter since. my
He
lord,
has appeared in the previous matter.
If your lordship,
Nana gave notice.
if
that
your
is
lordship,
why-
That's right.
if your lordship did all the matter appearing, Dr. Patru.
But which
Why
one-
you are not giving notice?
Immediately notification issued immediately.
So what? You will not give him a notice?
If your lordship direct, by tomorrow I shall mention. Since Dr. Patru is appearing,
দিয়ে দাও লিস্টে।
No, let
my lord,
it-
another leave, my lord, seeking.
মোশন এটা ওই আগের স্লিপটা দেখি, আগের স্লিপটা ওটা করে দাও মোশন টপ পরশুদিন।
My lord, seeking.
পরশুদিন কত তারিখ?
কি এইটার আলাদা তো, এটা তো সিমিলার ইস্যু, অর্ডারটা দিদি, ওটা তো আগের।
সিমিলার পরে দেখো।
হ্যাঁ, my lord, similar, my lord, seeking leave the similar matter to file.
ওয়েট হ্যাঁ 30th ওয়েডনেসডে ও জানে অমিও মোশন টপ 30 তারিখ মোশন টপ।
Proper notice, I shall come proper. My lord, similar issue, my lord, seeking leave to file this.
upon urgency when the the counseling
The 1st of August.
upon লিখে দিন আপনি, upon পেছনে লিখুন।
Wednesday,
Upon-
my lord, Wednesday.
No, sorry, no, unless number comes I will not allow. Upon urgency pleaded, leave granted to obtain regular number. After you get the regular number, mention tomorrow.
Lordship.
Upon notice to Dr. Patru.
My lord, may I be permitted?
Wait. দিয়ে দিন ওটা।
কি করবো, জুনিয়র ফিনিয়র সবাই মেনশন করে দিচ্ছে। দেখ, আপনাকে বলিনি আমি।
কি হয়েছে? Upon urgency pleaded, leave granted to obtain regular number. লিখে দিয়ে দিন।
My lord, in prescribed proper, I needs to put one date. In prescribed form, I needs to put one date. My lord, if the date is not given, that particular matter will appear that.
Sorry, no. In lot of matters, I do the same practice. After you obtain the number,
Only 48 hours date is given.
That
That is given.
I am giving.
you give whatever you want. Yes.
May I permit to mention? Well, my lord had passed an order in this matter, my lord, thereby directing the Commissioner, Howrah Municipal Corporation in the West Bengal Highways Act 1964.
No more with me.
No.
Municipality, no more with me.
No, order has been passed.
So
I
doesn't
want,
matter. Go and
I-
mention before regular.
no, as per my lord's order is to be recalled because order has been passed, disposed of.
Huh.
In that, my lord, Commissioner HMC was directed to give the hearing and pass an order. But as per statute in the Highway Act, the district magistrate is the appropriate authority. Unfortunately, I was not there.
I will not take up. Mention before the regular meeting by taking up proper action.
But then releases the matter
Why I release?
because I have already filed an application before your lordships. Before your lordships, I have filed an application for modification.
When the application will come, I will do that.
For that reason, let the application comes before your lordship.
To be mentioned tomorrow.
My lord,
Give the application.
application number I have given.
My lord, may I permit to
To
mention?
be mentioned tomorrow.
My lord.
Permit to mention also this upon notice, the petitioner initially appointed as a organized teacher.
Huh?
Petitioner is appointed as an organized teacher initially. Thereafter, the same organization has been recognized by the West Bengal Board of Madrasa Education, and the name has been said, except excluding my the name of the petitioner.
What is the urgency? Jasi Bhattacharya's determination.
Lordship, this is
What
the-
is the urgency? It cannot wait till tomorrow.
Lordship, because it is filed on 20th March 24. After lapse of one and a half year, this matter is not.
All right, mention before his lordship.
My lord, item number
So all the matters are
131 of
urgent.
my lord's brief. my lord list 131, I am praying for upgradation. In this matter, petitioner is a
Service matter.
service matter, is a ageless peon of under the judgeship of South Chobbish Pargona. Thereafter, he transferred to judgeship of Murshidabad. In the where he has been appointed as ageless peon, but assigned as night guard, assigned the duty of night guard.
Emergency. Next.
My lord, I am on leave, my lord.
Next.
Leave is going to.
My lord, this is a prayer for upgradation of the writ petition.
Show me the urgency. It cannot wait.
My lord, this patient, the
Service
petitioner-
matter.
Yes, the petitioner is an employee, is a scheduled caste, an employee of Pollution Control Board, West Bengal, a critical kidney patient, undergoing dialysis 3 days in a week. Now it is 118 in the daily list. If you kindly,
What is the relief?
it's a arbitrary action regarding promotion by West Bengal.
Promotion. It can wait. Promotion has got nothing to do with dialysis.
Your lordship, may I be permitted to mention
My lord, I do not know how long she will survive. This is the question.
If he gets, he will get the benefit.
If he doesn't survive, how?
All right, next.
May I be permitted to mention one matter for upgradation, your lordship? This matter pertains to enhancement of a pay scale of a Group D staff who was working from
No urgency. Next.
Lord, praying for upgradation of item number 137 of ASD, sir.
Take the microphone, sir.
Sorry, my lord. My lord, the petitioner has been dismissed from service. He has preferred an appeal, my lord. He is having minor child. My lord, the appellate authority is not disposing of the appeal, my lord. Only prayer for direction upon the appellate authority to dispose of the appeal, my lord.
Where is your other side?
My lord, it's a new motion, my lord.
Where is the other side?
My lord, I
Where is your notice?
my lord, it's a new motion, my lord.
So what? You will not give notice?
My lord, I have served notice. Affidavit of service is ready with me.
No, no, that you will be mentioning today.
No, my lord.
Give notice and bring the other side.
My lord, I'm so grateful, my lord.
My lord, mentioning the service matter, the matter was fixed for hearing in the monthly list of March 2025.
By
Sorry, my lord,
by me.
by Orindam Banerjee, Lordship
No,
Orindam
there
Banerjee.
is no learned judge. Next.
Since March 2025, matter was delisted, praying for
Inclusion. There
inclusion.
are, sir, madam, wait for some time. Next. Mention after puja vacation. Next. Dakho.
Mentioned matter. Item number 1.
In this matter, my name should be corrected. I appeared for state. Led by.
This matter has appeared today under the heading to be mentioned at the instance of the learned state advocate. Full stop. She submits that in the order dated, in the judgment dated July 23, 2025, her name is mistakenly recorded as MS Ranjana Das. And the same should be corrected and read as MS
Ratna Dash.
MS Ratna Das, advocate. Full stop. Paragraph. This correction shall be incorporated in the judgment dated July 23, 2025. Next.
Gratuity matter. Item number 2.
Lordship, we will receive the brief today. So please allow me to come tomorrow.
In all 20.
Yes, 29.
All 20. When you have served?
Much earlier, Millet. It had been served much earlier, Millet.
I am for the respondent of
21.
এই মামলা আর দেবো না লিস্টে এইভাবে
item number 2.
Similar matters, Millet.
এই মামলা দেওয়া যাবে
There, Millet.
লিস্টে 20টা ম্যাটার এইভাবে এসে অ্যাডজেন্ট হয়ে যাবে
অর্ডার হবে
দেওয়া যাবে না সকালবেলা বসে লাভ
একই অর্ডার হবে
Orders have already been passed.
Okay, ma'am.
Millet.
এভাবে দেওয়া যাবে
একই অর্ডার হবে
Okay, my lord.
Your lordship's already passed order earlier. Similar order only.
এই মামলাগুলো ছেড়ে দিন, ওই নেক্সট ইয়ারে পাঠিয়ে দিন, এই লাভ নেই।
We will suffer, millet.
20 matters, madam.
করে দিন।
My lordship.
20 matters. I have to pass a 20 order for this.
নাম থেকে চেয়েছে করলো।
ঠিক আছে, এগুলো যা দেবে দেবে, আর লিস্টে দেবেন না। ও পরে যে আসবে আসবে, যা করবে। There must be some limit.
So at the end of the millet, the petitioners will suffer, millet.
This cannot done like this. 20 matters simply.
Well, I am representing my state respondent, my lord, respondent number 1.
I am for the item number 11 for the state.
And there was a direction to.
I am for the state in 20.
Look at,
Item 15, I am for
Item
the state.
20, I am for the
look at.
State 14. I am for the state, my lord, in item 15.
Only, my lord,
in 20.
your lordship's order will be followed in the earlier orders.
Okay, my lordship.
Have you corrected all facts and
Yes,
figures?
millet.
Show it to her.
They know, millet. Difficulty is, millet.
When you serve, sir,
Millet, it had been served on, millet, 25th of July, millet.
It's
and
28,
today we are on.
28,
20.
Saturday, Sunday.
You also said as if it is served 15 days back. When I
Saturday,
asked you, you said
Millet,
long back.
millet, I'll tell your lordship, 24th and 25th, 2 days.
এই এগুলো 5টা বার করে বেরিয়ে যান, ও লিস্ট থেকে বের করে দেবো। লাভ নেই দেখি।
This is agreeable to my lord proceeding. This is agreeable to.
Okay, my lordship.
What?
Okay.
Very,
If you want to do the.
And you also submitted extremely well your advocacy. I asked when you have served, you said long back. Started with the sentence long back. Naturally, long back is a very relative expression.
At least 15 days.
You said long back.
I apologize, millet, millet. Difficulties, millet. So many matters are there in your lordship's list, millet. From 80 to 130, millet. They are also similar matters, millet. Actually, they had been served, millet, long back, millet. I was a bit confused, millet, but I did not.
Do one thing.
My lordship.
These matters I am passing order today.
Millet,
Okay, my
millet,
lordship.
Similar matters which are there,
millet,
Okay.
sort it out from the list.
millet,
Sort it out from the list, make a chart,
millet,
Well,
sitting with your other side,
millet.
my
and
lordship.
then give it to me, give it
Very
to my
good, very
officer, mention it,
Okay,
then
my
we
lordship.
shall
Very
do
well,
that
very
Okay, my
very
lordship. Okay.
accordingly.
Okay, my lordship.
আসুন এটা দেখিয়ে নিন, you look at it, madam.
চেক করলাম, কিছু বুঝতে পারছি না, ব্রিফই তো নেই।
2 নম্বরটা। এই 2 নম্বরটা।
হ্যাঁ, 2 নম্বর।
And বসুন। What is the name of the for petitioner? আপনি দিদি শুধু আইটেম নাম্বার দিয়ে নামগুলো রেকর্ড করুন। Petitioner, your name.
Srinjoy Sengupta, millet.
Mr. Srinjoy Sengupta for the petitioner. MS
Pৌlomi Chattopadhyay.
Pৌlomi Chattopadhyay for
Responded Transport Corporation.
CSTC.
CSTC.
CSTC, Mr.
Mr. Robindranath Dotto.
Robindra Narayan Bhattacharya for Robindranath Chattopadhyay for
Robindranath Dotto.
Robindra Narayan Dotto for
For respondent number state respondent.
your state.
I am for the state in 11, item number 11.
11 ডাকি না এখন।
Oh, I'm fine, I'm fine. I'm
11
extremely.
ডাকি না এখন। 2 নম্বরটা দেখি।
এই হচ্ছে মুশকিল। If leniency is taken as advantage, taken for granted, then it is difficult.
Item number 3.
আচ্ছা আস্তে আস্তে ডাকুন, আপনি আস্তে আস্তে গোছান। একবার দেখিয়ে আমায় দেখান অর্ডারটা।
একটা ওটা ওই অর্ডারটা কারেকশন করে দেখিয়ে দিই।
একটা just একটা দেখিয়ে দিই।
2 নম্বরটা।
বসুন, আপনি তো এটা জানেন না।
দিয়ে দিয়েছি।
এই
You have checked up, madam?
Yes, my lordship.
Well, then item number 2, may I leave, my lord?
And if they come up for correction after while, you just point it out to me. If they come up for any correction on facts and figure, right? You just point it out to me then.
Okay, my lordship.
কপি দিয়ে দেবে নাকি সুবিধা হবে
Hmm.
দিয়ে দিয়েছি
Srinjoy Sengupta, Poulomi Chattopadhyay, and state.
See, I am appearing for the state.
Mr. Aste. State ke 3 number?
Item number 3.
Huh.
Bimalendu Das, advocate for the state.
Mr. Bimalendu Das, learned advocate for state.
And also Vishwanath Samant.
And Vishwanath Samanto for state. Give it. Next.
কোড দিয়ে দিলাম তো
Give your name. And you also submit your name. What is your name? Devduti Dotto for state. In all 20 you are there.
Yes, my
And
lordship.
you all 20 you are there.
2 to
So
21.
Srinjoy or Poulomi, common.
Common. For West Bengal Transport Corporation.
WBSTC.
Yes, ma'am.
WBSTC. লিখবেন হ্যাঁ আর ওনাদের
WBTC.
লিখে দেবেন স্টেট
WBTC Limited.
TC.
ও WBTC
West Bengal
আর
Transport
ওনাদেরটা হচ্ছে স্টেট WBTC নেক্সট শুধু স্টেটের নামটা ভ্যারি করবে নান অ্যাপিয়ার্স ফর দ্য স্টেট পরে কোনো নাম ঢোকাবেন না কেউ দিলে নেক্সট
Item number 7.
7.
স্ট্রেট
না একটু বলে দিন তাও ইউ জাস্ট টেল ইউর নেম অলসো
দেবনারায়ণ পাত্র এন্ড দেবাশিস দে
Item number 8.
In every matter, you are submitting the affidavit of service.
Item number 9.
যেগুলো স্টেট রেসপন্ড করছে না নান অ্যাপিয়ার্স ফর দ্য স্টেট না যেগুলো করছে না ওনারা তো করছেন সবাই
Item number 10.
My lord, I am for the state in item number 10. My name is Sharmila Dattadas.
থ্যাংক ইউ
Grateful, your lord.
Or I am for the state. Item number 11.
all of you sort out these type of
My lord.
matters from the list, sit together, make a list and then mention. I will direct them in phase manner. I will direct them to appear.
I
Okay,
have
my
that
lordship.
with me only, millet. 82 millet.
Do
100
that.
millet. I will sit with her today.
Item
only.
number 12.
These are basically incentive to the juniors. So that
Item number 13.
13.
and especially before vacation. Sort out, madam, sort out the matters.
Okay, my lordship.
Item number 14.
I'm for the same.
14.
My lord, I am for the state Muhammad Farhaduddin. I'm grateful, man.
15.
I am appearing on behalf of the state, my lord.
16. 13 state. 13.
যা হয়ে গেছে আর তো পড়া যাবে না।
So that one soul, only one. I have come just you completed 13.
What is your name?
Gautam Basu.
Gautam
Basu.
আর যেখানে কেউ রেসপন্ড করছে না দিদি, নান অ্যাপিয়ার্স ফর দ্য স্টেট। আরে আমার এইগুলো ওখানে কেন, নোটের খাতাগুলো? হ্যাঁ, এগুলো অমিও রাজি, এগুলো বেঁধে আমার ওই চেম্বারে পিএ কে দিয়ে দেবে।
I am for the state, my lord.
Your name? Bikash
Goswami.
Bikash Goswami for the state.
I'm with learned GP, my lord.
Give the name.
I've given the name.
I am appear for the state. I'm grateful. Let I apologize to late for.
It's all right. Better sort it out.
Yes.
Sort it out so that things can be done.
Yes. And thereafter I will mention them.
You come up with the list. Both of you mention.
Fine.
UPC has not sent the report to me till now.
There is a deduction.
Although there is a
direction for
filing a report, but the UGC has not yet sent me the report.
UGC, Grant Commission.
University
Grant Commission.
Well, kindly give me a 1 week time.
On the prayer of MS
Devjani
Ghoshal, learned advocate, appearing for UGC. Time to file report on affidavit. Stands extended parenterally till. Ajit koto didi? When?
Let it be fixed after 15th because it will be coming from Delhi. I don't know. It will be coming from Delhi. After 15th.
At least some days prior there to let me.
Soon, I did to be served. Advance copy will be served.
18th, August 18, 2025. Exception in the form of affidavit thereto, if any, shall be filed on or before.
1 week thereafter.
27th.
Fine.
August 27, 2025. The writ petition shall appear under the heading motion top. On September 2, 2025. 2nd September.
I am for the other respondents. There is a preliminary issue that this court has lack of eligibility.
Mr. Sahasranshu Bhattacharya, Learned Counsel, appears for
Union of
Union of India, who has already raised a point of maintainability on the earlier occasion, comma, the same shall be taken up first.
The maintainability point will be kept open.
First, I will hear that. Then I will proceed with the writ petition.
Because I have placed one Delhi High Court judgment, what in the same matter, the same this authority, I have handed over the copy of the order.
No, that is not waiver of jurisdiction.
I have prayed, my lord.
That has been recorded.
Sir, if I lack territorial jurisdiction, I will not touch it.
My lord.
If I don't lack, I will touch
My
it.
lord, that is my respectful submission.
My
lord.
Sure.
2nd September. Item number 23.
My lord, I am for the petition.
And for respondent number 1, my lord, that is Union of India.
Well, there are two set of affidavits, one at the time of filing of petition and service, and subsequently upon mentioning, my lord.
Take the microphone, this microphone.
Subsequently upon mentioning, my lord, made a precondition that the service of, upon mentioning, has to be served on the respondent parties. That was
Affidavits of service filed in দিদি এখন একদম কাউকে এখানে ঢুকতে দেবে না, কোনো কথা বলতে দেবে না, হয় 1:30টার পর না 4:30টার পর। ঠিক আছে বাবা, তোমায় বলছি রাজীব,
না
বলে দেবে জজ সাহেবের বারণ আছে। Affidavits of service filed in court today are taken on record. ঠিক আছে। Yes.
My lord, only the short point is the petitioner alleges a 19-year-old boy, aspirant of joint entrance examination. He claims that he has performed well in his physics theoretical exam for his class 12th higher secondary exam before the board in IOS, National Open Schooling. And he has scored well. But however, he was not awarded any marks in the theoretical exam of physics. Now that has become a situation wherefrom, even if I succeed,
that's a different, that's the second stage.
That is a second stage.
Who is appearing for the board?
Board.
My lord, I'm not appearing for board. I'm appearing only for.
Who is the answering respondent?
My lord, respondent number 2. Respondent number 2 and 3.
Two and 3.
Yes, my lord.
They hold high secondary examinations.
Yes, NIOS, National Open Schooling, which is equivalent to higher secondary.
Where are they?
Well, they have been served. I've given certificates.
Who normally appears?
But I am appearing for the first time, so I am not aware that who is appearing.
Any idea?
So, my lord, I have no idea.
Well, let there be one's direction for appearance and to.
Where is your mark sheet? Show me.
Yes. Well, it comes to page 10. 10 and 11.
Page 10.
10 is the mark sheet. 10 is the admit card.
Okay, Tate, you show me that where from it will appear you have been awarded no marks.
11. Page 11. Physics.
Mathematics.
Physics. Physics.
0, 00.
Yes, yes.
UD 00.
Is there any provision for review?
There is, and that was also attempted. And an email to that effect was also sent by the student. But however, the response is very unusual. They wanted me to appear in another board exam, which is coming up in 2 months' time. So I do not know the reason. I have fairly done well in my examination.
How can it be after 2 months if the
if it's yearly? No, there is a provision like anybody.
In April and
is it not a yearly examination?
No, it is an open schooling which is giving opportunity to all those who are settled outside the.
Are these institute affiliated?
Yes, they are central government. They are absolutely governed by the central government. This is National Open Schooling. And they cater the service of providing the scope of appearing in board examinations for those who are actually workmans, mostly are workmen.
Sir, what I will do, I will simply direct you to serve upon them, and they must come up with all records before the appropriate bench, before the regular bench. Right? Before the regular bench, and the point of maintainability of the writ petition shall be kept open.
Lordship, one difficulty is like why we have come over here because of urgencies. The urgencies, my lord, like on one side, we do not have any problem if the matter is taken up in the regular bench, but the regular bench will sit only after 2 weeks, as I have heard.
Correct.
Orally. Now, situation is that joint entrance examination result were due on 24th June. 24th June. Now, due to one matter regarding to OBC and their spaces in the services and educations, that is the result of the joint entrance has been kept in abeyance. Due to now, it will be subject to the result of that Supreme Court matter, which is deciding about OBC and
No
all that.
urgency at all.
No, Lordship, the situation is
Mention before, you do it before the regular.
one direction for production of the document will also
subject to maintainability, because I have my every doubt whether this writ petition is maintainable two-way. First, whether the authority is amenable to jurisdiction. Secondly, whether the provision for review is there.
The provision of review is there.
I have my doubts.
Yes.
So unless you argue that and they take that point, I don't come to a conclusive finding.
My lord, one more opportunity for another set of service upon the respondent.
Yes, that's what I'm doing, and I'm making it returnable with liberty you to mention before the regular bench.
And also this bench, Lordship?
No. Next. Ashu. Upon urgency being pleaded, on mentioning, upon urgency being pleaded, and since the determination of the regular bench has been assigned before this bench, before this court, this writ petition has been taken up for consideration by publishing in the daily cause list. Referring to page 11 to the writ petition. Mr. Your name, sir? Your name?
Oh, Rabiuddin Ahmed. Rabiuddin Ahmed.
Mr. Rabiuddin Ahmed.
B for Rabi, RABI.
Rabiuddin Ahmed, learned advocate, submits that the petitioner has been awarded 00 bold out of 100.
Out of 80, Lordship. Out of 80. Oral is 20.
Oh, out of 80 in the physics written examination for class 12 board. The petitioner has challenged this.
My lord, one indulgence, may I? My lord, comes to page 11 once, just to show that whether they are amenable under the scope of the writ petition.
Fine, sir. I'm keeping.
It is an autonomous institution under Ministry of Education.
Autonomous University, Ministry of Education is so many private organizations. আচ্ছা, মাথার উপর affidavit of service filed in court today is taken on record. তারপর theoretical, physics theoretical. Paragraph. The answering respondents are respondent number 2 and 3. They are not represented despite notice. Union, you are there.
Yes, madam.
MS, paragraph. MS.
Taposhi Sinha Palit.
Taposhi Sinha Palit, learned advocate, appears for respondent number 1.
Madam, along with my senior Mr. Rananjoy Chatterjee, madam. He is on.
Taposhi Sinha Palit, learned advocate, led by Mr.
Rananjoy Chatterjee, madam. I have given the slip.
Mr.
Rananjoy Chatterjee.
Rananjoy
Yes, madam.
Chatterjee, learned advocate, appears for respondent number 1.
That is Union of India.
Class D, Union of India. Paragraph. In absence of respondent number 2 and 3, this court thinks another opportunity should be given to them to explain their stand. Poster. The respondent number 2 and 3 shall bring the relevant records relating to the petitioner in the light of the mark sheet at page 11 to the petitioner. I am petition. Before the when the matter shall be taken up next. Paragraph. However, the question of maintainability of this writ petition is also kept open, which shall be decided first on the next day. Paragraph. The petitioner shall also make his submissions whether review of the answer script is permitted under the relevant law. Full stop. The matter shall appear before the regular bench. Full stop. This urgency, no urgency is going since 6th of May.
No, Lordship. The result was due on 24th June.
6th of May, I find an order of Justice Vishwajit
Yes,
Bhatt.
yes. That was in a wrong direction. Yes.
6th of May.
Before the regular bench. Paragraph. Petitioner shall be at liberty to mention before the regular bench upon notice to the respondents. Full stop. Paragraph. Petitioner shall serve a copy of today's order upon respondent numbers 2 and 3 and file an affidavit of service when the matter shall be taken up next. Sure. Next.
Item number 24, adjourned application.
Appear on the roster. Petitioner. The direction for filing affidavit in reply. Affidavit in reply.
It's an application.
Application, Your Lordship, review application. They have already filed their opposition. I am filing my review. আগের দিন আমি নিয়ে আসিনি বলে দিতে পারিনি, আমার তো ফাইল করা ছিল। আপনারা
হ্যাঁ, ওদেরটা আগের দিন জমা পড়েনি, আগে
জমা পড়ে জজ সাহেব the last occasion.
This is RVW 100.
Yes.
100. Ashun. RVW in Ray RVW 100 of 2024.
That copy was served earlier upon us. That copy was served earlier upon us.
I have already served them.
So I will hear first RVW 100.
Yes. That is appearing in the list.
In Ray RVW 100 of 2024. Mr. Shonojit Kumar Ghosh, Learned Counsel, appears for the writ petitioner, stroke respondents in the review application. Mr. Shumon De, Learned Counsel, appears for
For the review applicant in RVW
Okay,
298.
in this RVW 100,
100, RVW 100,
you are not there.
not there.
Sit down.
School is party, I think. School should be a party. Yes, for the 7 and 8, my lord. I've been made party.
So you will appear or not? That's up to you.
Yes, my lord. My lord.
Mr. Shuman De, Learned Counsel, appears for
Respondent number 7 and 8.
7 and 8 in the review application.
Review application.
In the review application. Yes. Show me the order. আচ্ছা আরো মাথায় লিখুন Mr. Shagnik Chatterjee, Learned Counsel, appears for the review applicant. State a stroke.
The respondent numbers, I was not sure.
State. Response stroke state. তারপরে তো ওইগুলো হলো নামগুলো, হ্যাঁ? Show me my order.
Your Lordship, at page 136, it starts off can 1.
আচ্ছা can 1.
Can 1, if your Lordship takes up.
এই ওই অর্ডারের ফাইলে আমাদের ওই ডিভিশন বেঞ্চের অর্ডারটা আছে তো, একটা আপনি বের করে রেখেছিলেন, একটু হাতের কাছে রাখুন বের করে ফাইলটা। Yes, sir.
Lordship, affidavit of service filed in court be taken on record on the prayer of Mr.
Take your microphone.
Yes, on the prayer of Mr. Shanojit Kumar Ghosh, learned advocate, appearing for the petitioner. Time to file affidavit in reply stands extended till today. It has been filed. Mr. Shanojit Kumar Ghosh, Learned Counsel, led by Mr. Shubhish Chandra, Learned Counsel, appears for the petitioner. None appears for the respondents. The affidavit of service filed today in court shows that affidavit in reply with all annexures was duly served by the petitioner's advocate on record through a forwarding letter dated such and such upon Mr. Shagnik Chatterjee, who appeared in the matter even on December 12, 2023. The endorsement on the forwarding letter shows it was received on January 19, 2024. The original affidavit in opposition is not available on record. The petitioner claimed to have worked as the headmaster of one Shyamnagar Kanti Chandra High School. The petitioner retired on October 31, 2019. Prior to his retirement, the petitioner submitted all his relevant documents.
Can one পড়ছি তো 100? হ্যাঁ তো এটা তাই আছে রিপ্লাই এটা। Yes sir.
The petitioner retired on October 31, 2019. Prior to his retirement, the petitioner submitted all his relevant documents on April 22 such and such for the purpose of preparation of pension payment order annexure P4. The necessary clearance and the online acknowledgement is available at page 56.
Take the microphone, be louder.
On June 3rd, 2019, the school through its headmaster submitted the final pension file for payment of pension in favor of the petitioner before the respondent number 3 to annexure P5. The relevant school also submitted the papers regarding final withdrawal of Provident Fund for the petitioner dated September 6, 2019 before the Jurisdictional Assistant Inspector of Schools at page 59. The relevant school also made a prayer before the Jurisdictional Assistant Inspector of Schools through its letter dated September 6, 2019. Annexure P5 for final withdrawal of Provident Fund money in favor of the petitioner. The said letter contains the endorsement of one Arun Guho being the president of the managing committee of the relevant school. On the basis of all these correspondence exchanged by and between the petitioner, school authority and the state authority, the necessary pension payment order dated November 7, 2019 was issued in favor of the petitioner annexure P5. The endorsement appearing at page 63 to the writ petition shows that the president of the managing committee of the school had duly taken charge from the petitioner for the post of headmaster wherefrom the petitioner had retired. Since retirement, the petitioner has made demands before the appropriate state authority for releasing his all retirement benefits, which includes pension, provident fund, gratuity, etc. But till date, nothing has been released in favor of the petitioner, though the petitioner had rendered his service since about 1987. Mr. Shanojit Kumar Ghosh, Learned Counsel for the petitioner, led by Mr. Sannal, Learned Counsel, submits that from the affidavit in opposition, though the original is not on record, but the affidavit in reply filed on behalf of the petitioner thereto is on record, it appears that a purported charge sheet was enclosed in the affidavit in opposition dated April 21, 2022. Since neither the school authority has been represented nor the state has been represented, no submission was made on the basis of the said alleged charge sheet. No sustainable material or ground is available before this court in support of the said alleged complaint lodged or charge sheet issued against the petitioner. After considering the submissions made on behalf of the petitioner and on perusal of the materials on record, it appears to this court that admittedly, the alleged charge sheet was disclosed for the first time through the said affidavit in opposition after 3 years of retirement of the petitioner. An alleged complaint dated October 1, 2019, Annexure P7 to the writ petition was lodged few days prior to the retirement of the petitioner by one Tanmoy Bishwas, who is acting as the teacher in charge of the relevant school since after the retirement of the petitioner, as submitted by the Learned Counsel for the petitioner before this court. It was also submitted that said Tanmoy Bishwas was at the material time an assistant teacher and a colleague of the petitioner during the employment tenure of the petitioner, but no such complaint was ever raised against the petitioner prior thereto. Record shows that the managing committee of the school duly took over the charge from the petitioner when he retired as headmaster without any objection or demur. No disciplinary proceeding was ever initiated against the petitioner during his employment. The petitioner had an unblemished career record at all materials time. The petitioner has rendered his service as a teacher since 1987 for about 32 years. In view of the above discussions and reasons, this court is of the firm view that there is no reason as to why the petitioner shall not immediately be released and paid with all his retirement benefits after rendering service for about 32 years in the facts and circumstances of this case. For the foregoing reasons, the appropriate authority and/or authorities are directed to take all necessary and consequential steps in terms of the pension payment order already issued in favor of the petitioner to release all the retirement benefits, including provident fund amount to which the petitioner is eligible, strictly in accordance with law, and shall disburse the pay the necessary payment by crediting the bank account of the petitioner positively within a period of 8 weeks from the date of communication of this order. With the above observations and directions, this writ petition along with application stand allowed without any order as to cost. So, Lordship, the main difficulty at that point of time was that neither the state nor the
first you tell me where you differ on facts.
No, you. No.
No difference of facts.
No.
So you don't deny these facts.
No.
Facts are admitted.
Now, the only thing is that we already prepared an affidavit in opposition. It was affirmed and served upon the petition, writ petitioner. And, Your Lordship, that since on that day the state was not represented, that was not handed over, that was not officially filed before Your Lordship, and they filed their affidavit in reply. In our affidavit in opposition, we have stated that since there was a charge sheet already which has been filed against the petitioner, so the petitioner was not since the disciplinary proceeding was going on, the petitioner was not entitled to all his retirement benefits. He was entitled to the provisional pension, and during this pendency of this review application, Your Lordship has allowed that the petitioner may be granted all provisional pension and the arrears as well. Now, on the last occasion, I must say this, Your Lordship, submit this. It fell from the learned advocate for the petitioner that we were paying the provisional pension in terms of ROPA 2009 and not on the basis of ROPA 2019. The revised provisional pension has not been paid. And Your Lordship directed us to obtain instruction why that was so. I have taken instruction on that. The difficulty was that there is a dispute with regard to his no liability certificate. No liability certificate, which is essential for processing the pension payment file. Initially, one no liability certificate was submitted, but the petitioner was the head teacher at that point of time of the school. Now, only after obtaining the handing over of the charge, after the retirement of the petitioner, it was found out that there were several defalcation of funds, mismanagement, and other things, on the basis of which the complaint was lodged, and subsequently the charge sheet was filed. So the difficulty was that the no objection certificate was no liability certificate was withheld by the school authority itself.
No, but what did your managing committee do then?
The managing committee took charge.
No.
Only thereafter.
During the tenure of the teacher? During the tenure before retirement.
At the school authority.
Yes. What did the managing committee do? The managing committee was supposed to point it out.
Yes.
They should have initiated disciplinary proceeding.
Absolutely.
So now after retirement.
No. Only thing is that, Your Lordship, why it was not given in 2019 revised scale. Since the no liability certificate was withheld in the portal, now everything is done online. In the portal, the application of the petitioner with regard to his pension, that is incomplete with regard to the 2009. Now, only after it can be processed and it is shown as complete, the revised can be processed. No.
So then you want a no liability certificate?
Yes, proper, because subsequently the no liability certificate which has been given by the petitioner himself, that is after his retirement, he has processed that and he has given it himself, not the managing committee, which is not in terms of the rules.
No, but what the managing committee did?
Managing committee, my lord, there was some headmaster himself being the ex-officio secretary of the managing committee. There was only one president at that time who somehow, my lord, acted at the behest of the headmaster. Other members of the managing committee was not properly, my lord, functioning. That person interested in education, he has been appointed by the department, but they have did not agree to work on that.
What steps you have taken then against?
Yes, there is a, my lord, steps has been taken. May I, after he finishes, may I just point out or just yes.
His case is limited to that extent.
Yes.
That the moment I will get a proper no dues certificate, I will release everything.
Yes.
That's your
thing. Only thing, my review application, my only contention is that since there is a charge sheet, which was already, I have annexed to the opposition, and it was brought to the notice of this honorable court by way of their reply. So after observing that finding, Your Lordship, in my respectful submission, ought not to have granted the entire retiral benefits to the petitioner. The disciplinary proceeding is already going on. If he's
disciplinary proceeding, charge sheet dated?
That is, Your Lordship.
Charge sheet.
Page 132, Your Lordship sees.
Charge sheet dated?
21st April 2022.
1 second, sir.
Yes.
Page 132
of the stay application.
Dated, sir?
April 21, 2022.
Date of retirement?
October 31, 2019.
Is this permitted?
Yes. Within 3 years from the date of his retirement, charge sheet can be filed.
Disciplinary proceeding
Within
can be initiated within 3 years of retirement. If this my lord, irregularity, illegality committed by any of the retired employee is detected, then to just overcome this kind of situation, a headmaster being all in one in a school, everything financial, every authority control.
Under which rule this should?
Yes. Just 1 minute.
In my affidavit in reply, your lordship will find at page 12.
Reply. What is that? What is that?
Rule is
This
there.
is Rule 5 of the
Rule 5 of the West Bengal Board of Secondary Education, appointment, confirmation, conduct
It is
and
annexed to reply.
yes,
reply.
my reply, your lordship will find at page 12. Rule 5 in the middle portion.
1 second.
Your lordship. The rule, it starts at page 8.
2018.
18
Yes,
rule,
your
my
lordship.
lord. Rule 5.3, last proviso.
Page.
Internal page 5.
Internal page 5 and running page 12.
Yes.
Rule 5.3, the last proviso. Your lordship. The disciplinary proceeding, Rule 3 says, Sub-Rule 3 says, if the explanation in reply to the show cause notice is not satisfactory, the disciplinary authority shall initiate disciplinary proceeding against the concerned teacher or non-teaching staff. The first proviso provided that no disciplinary proceeding shall be initiated after 3 years from the date of alleged misconduct becomes known to the board. However, the said period may be extended with the approval of the state government in appropriate cases. Provided further that in case of retired teaching or non-teaching staff, disciplinary proceeding may with the approval of the state government be instituted within 3 years from the date of retirement if the misconduct becomes known to the board after retirement.
So you're claiming benefit of this provision,
Yes.
second provision.
Yes. Second proviso. And he retired in October. We are within time. It was the charge sheet was filed in April. In case, your lordship. That is the limited scope of the review, that since the disciplinary proceeding is pending, he is not entitled to the entire benefits. Everything your lordship has directed, that is absolutely correct. Only with regard to the entire retiral benefits, he is not entitled to that.
With the leave of my learned friend, my lord, may I just place, since my lord is on this rule, the penultimate clause, my lord, at rule 9, internal page 7. Penalties. If a teacher or a non-teaching staff is found guilty of any misconduct, the disciplinary authority may, where the misconduct is not grave or criminal in nature, give him reasonable opportunity for rectification of such misconduct. The disciplinary authority may, by final order, inflict any one or more of the penalties as mentioned below upon a teacher or a non-teaching staff after going through the procedure as prescribed for disciplinary proceedings. My lord, the penalties, my lord, are next: censure, withholding one or more not exceeding 3 annual increments, stoppage of career advancement scheme benefit, deduction of pension amount or gratuity amount. And we are on that there is a, if the appropriate authority, my lord, finds after this proceeding that he is guilty, and if they only weigh out, my lord, since this retired, there's to, my lord, impose D. So if my lord directs, with my humble, my lord, submission is that then the disciplinary authority will be precluded from initiating appropriate proceeding, appropriate penalty. So other are not applicable for him. That's removal or dismissal.
The charge sheet.
Yes.
What is the charges
Page 132
of
the stay application, CAN 1. (132), your lordship. The charges are the one, that allegedly disparities regarding midday meal have been noticed during his term as headmaster. Number 2, that allegedly he commenced construction work in the school without discussion of the finance subcommittee. Number 3, that allegedly he collected excess fees from students in violation of the Right to Education Act 2009. That allegedly he collected money from the students for the purpose of health card without any government order. 5 is important, your lordship, that allegedly he has been running 12 bank accounts in the name of the school and withdrew large amounts of money from the bank without any resolution of the managing committee. That allegedly he played a vital role in the illegal selection of TIC of the school. Mostly are with regard to defalcation of fund. The only way the state or the school authority can recover it is by through his pension amount or the gratuity amount. That is the difficulty the state is facing.
Although all the illegalities part we have relied on in our stay application, even if we are we do not go into the deep of the all these documents, but finality is that, my lord, that DI has inquired, a SOCAS has been issued, permission has been obtained from the government, this proceeding has been followed, and after all the board has stepped into the proceeding and this it has come up to this charge sheet process.
Your lordship will kindly see page 131 once, the no liability certificate which was given by him, which was processed by the petitioner himself.
Sorry.
Page 131, if your lordship kindly sees once. This was annexed to my opposition as well. 131 is the no liability certificate which the petitioner himself processed after his retirement. He retired on October 31, 2019. Your lordship will find the
11 November.
11 November 2019 and done by Alok Kumar Mollik. Your lordship, just 2 lines above that, your lordship will find that it has been done by the headmaster himself, the retired headmaster. Issuing the no liability certificate in his own.
Let me hear him.
Grateful.
Well, the facts are not disputed. Well, if I recollect correctly, the opposition of the state and school both were placed by me before your losses during the hearing to draw the facts. Now I take your losses to the charge sheet. They are harping on the charge sheet. Then I will take your losses to the grounds for review. This is a charge sheet after 3 years. Almost. If I
3 years, no, within 3 years of retirement.
Within, just I take your losses. The date of retirement, I just give you losses.
October 29.
No.
31st October 2019.
31st October 2019.
6 months prior to 2.5 months, half years.
Well, your losses will find this charge sheet was based on the report of a DI of 2021. But I'm not mentioning the date. Now your losses will find that according to them, these are the charges. Now your losses, misappropriation, all that. There are 6, I find.
Subject to be proved.
That's different. Now that's far-fetched, my lord. I'm not on that even. He is giving a fortnight time from the date of receipt of this submission of clarification. My lord, there cannot be any clarification if it is a charge sheet. Failing which it may be assumed that he admitted to all charges. I will take to the rules your losses. I brought it to your losses notice because this is non-est in the eye of law. Why I'm telling you losses? My lord, kindly come to the rules my learned friend has placed it. Lord, I'm straightway going to the provision. First your loss, then I will take to the other provisions.
Sub-rule 3, second proviso. Because they are relying upon this.
5.3.
5.3. Second proviso. So for first proviso is not applicable according to them. Provided further that in case of retired teaching and non-teaching staff, disciplinary proceedings may, with the approval of the state government. What is the approval, man? What is that? Just doesn't mention so. Just doesn't mention so. Without approval, you have just kept it pending because of the teacher in charge. I have served almost 30 years. No allegation against me. Now, after retirements, 2.5 years, without the approval of the state government, you were just serving a charge sheet, not serving. That's another point. You have issued, kept it in your pocket, annexed with the affidavit in opposition. So, this is ex facie, non-est in the eye of law. If they cannot show right now from their brief that this is an approval, so it should immediately. That's why your lawsuit did not take into consideration. Now, come lawsuit, the second sub-rule 5. In all cases for the purpose of inquiry, the disciplinary authority by an order in writing shall appoint an inquiry officer. Okay, my lord? This normal procedure your lawsuits will have. Next page your lawsuits. Sub-rule 6. The disciplinary authority shall serve or cause to be served on the teaching and non-teaching staff a copy of the charges not yet been served. Then your loss is very vital, containing a statement of imputations of misconduct. I respect all of my learned friends. I believe they understand the language imputation of misconduct. They have at least 10, 12, 15 years in practice. They have seen the misconduct of imputation of misconduct, what is called for. There should be narrated a detailed allegation with all details so that I can deal with it. Just to stall my payment, retirement benefits after 2.5 years, you cannot show half upon me or foist upon my pocket a document showing charge sheet. Imputation of misconduct, including any admission or confession made by the teaching and non-teaching staff with annexure list of documents. But I am putting a question to where are those documents? Have you annexed with the charge sheet? You prepared hurriedly because you have to prepare it. A list of witnesses. Who are the witnesses, my lord? 2022, I got 2025. By which and by whom the charges are proposed to be substantiated. With a direction to file a written statement of defense to the inquiry authority within 30 days from the receipt of the charge sheet. Now, this is not technicality or lawsuits. This is deals with the principles of natural justice. First, you serve me. Justice, you can't say with the issuance disciplinary proceeding starts. You can't say. First, this is lack of approval. Second, there is no service upon me. Well, suspension I can understand. Even if it is not communicated, it takes effect from the date. Issuance with the charge sheet disciplinary proceeding initiated, but that has to be served upon me. And third, your lawsuits, where are the list of documents? What are the charge? One line charge you are dealing with. It's a capital punishment after retirement to a teacher. You have stalled everything. By the grace of your lawsuits, order, you have given me provisional. I will deal with your lawsuits, the no due certificate. They were in the helms of the affairs. I am the ex officio secretary. I am not the, whosoever becomes the headmaster, he becomes the ex officio secretary. So, this is not the charge sheet even either. So that your lawsuits, that's why dealt with if lawsuits. Kindly look at the your lawsuits judgment paragraph. I just take your lawsuits.
Order under review.
Yeah, order review. Internal page 4. After considering the submissions made on behalf of the petitioner and perusal of the material on records, it appears to this court that admittedly the alleged charge sheet was disclosed for the first time through the affidavit in opposition after 3 years of retirement of the petitioner. And alleged complaint letter dated 1st October 2019. Well, this was made by the teacher in charge, who is against me all along. It was lodged few days prior to the retirement of the petitioner by one Tanmoy Bishwas, who is now acting as teacher in charge of the relevant school since after the retirement of the petitioner as submitted by the learned counsel for the petitioner before the court. It was also submitted that they said Tanmoy Bishwas was at the material point of time an assistant teacher and a colleague of the petitioner during the employment tenure of the petitioner, but no such complaint was ever raised against the petitioner prior thereto. Facts are undisputed even before your lawsuits today. If he is so vigilant, he could have raised it during my entire period of service. It didn't happen in a day, because according to me, I'm an almost habitual thief. Now they're trying to misappropriation. It's a modest term, actually thief. Now, in so long during my entire period of service, you could not do it. Then your losses can see. Record shows that the managing committee of the school duly took over the charge from the petitioner when he retired as headmaster. What else, my lord? Without any objection or demand. I will tell you later, this was undocumented. Your losses finding based on document. No disciplinary proceedings were ever during his employment. The petitioner had an unblemished career record at the material points of time. The petitioner has rendered his service in 32 years. Lord, I have to swallow it now. For 32 years, they could not. In view of the above, there is no reason as to why the petitioner shall not immediately be released and paid with his retirement benefits for about 32 years. Now, your losses, can you look at the grounds for review?
I'm just coming for 5-6 minutes. Doctor? Coming for 5 minutes. কে আসেনি আসেননি
No, I take your lordship to some of the documents now. If your lordship kindly take up this stay application, CAN 2, review 298. Then once, my lord, for few minutes, I will take your lordship to the rules again.
So those are not here in 100, RVW 100?
RBW, my lord, I'm not sure. RBW 100, আছে ওতে documents গুলো? কই? RBW 100 কই?
এই যে আপনি page 76
কই দেখেন? Just a minute, my lord. এটা কি? RBW
100
এতে আছে ওই জিনিসগুলো?
76 110
না, ওগুলো না।
এটা মেমো এই যে ক্যানটা দেখুন
Can. No, probably your losses will not be getting it to that. Your losses, my lord, CAN 2 of review 298. I'm saying how they're without authority and total non-est of law.
Page
209. কার জানি না ভাই তোমাদের
98
Can.
RBW
This is by the disciplinary authority of the board to the commissioner of school education. Well, kindly see. Subject: seeking permission for initiation of disciplinary proceedings against the Alok Kumar Mollik, retired headmaster of Samnagar such and such high school, North 24 Parganas.
This is for that approval.
Exactly. Seeking approval. This is of 1st November 2020.
1st January.
Sorry, my lord, 1st January 2020. After my
One second. 3 months after retirement.
Exactly.
3-4 months.
Now, this is your lordships by the board, disciplinary authority to the Commissioner of School Education. In terms of Rule 5.3 of the notification dated 8th March 2018, you are requested to accord necessary permission for initiation of disciplinary proceedings against Sri Alok Kumar Mollik, retired headmaster of Samnagar, Kanchi Chandra High School, North 24 Parganas. The inquiry report signed by the District Inspector of Schools, Barakpur North, in the instant case, has been enclosed with this letter for your kind perusal, where the charge of financial defalcation of school fund against the Alok Kumar Mollik, retired headmaster, has been prima facie substantiated. So they're asking for approval. Well, kindly have a look at this next page. Thereafter, my lord, almost after 1.5 years, they issued show cause notice. Kindly.
Oh, no. Next page is what? Show
To
cause notice.
show cause.
The same show cause you have shown me.
That's charge sheet.
That's charge sheet.
1st October 2021.
One second. What happened to this approval letter?
At least, my lord, I do not find anywhere. I'm taking that too. My lord, the approval letter, you'll see 1st January 2020.
Seeking approval.
Seeking approval. Then next page, you'll see 1st October 2021. Almost after, my lord, a year and 10 months. They are issuing show cause notice no my lord, permission is mentioned.
Yes.
Kindly have a look at this. For two purposes, I am showing it. When they can issue show cause notice, and this show cause notice also do not mention any prior approval of the state government after 3 months.
It does not refer to any
Refer
prior
to even.
approval.
So these are the two things your lordships will find. Allegations. Then your lordships kindly come to the charge sheet. Charge sheet I have given it to your lordships in a separate manner. I do not find here charge sheet.
No, you just now show me.
Just now, your lordship, from the another document, I think.
Another, the RV 100.
100. Yes, 100. Affidavit in reply 100.
132.
130. Now, my lord, kindly have a look at this. I placed it. It refers to the show cause letter, but doesn't refer to permission. Proper doesn't approval or approval. So, my lord, they with the so-called report of the DI as regards defalcation of money or misappropriation of money by me was sent to the state government. State government keep mum. What does it mean, my lord? State government did not find any material to give approval.
No approval given.
That's your losses. Then your losses. Now, kindly have a look. This is, I have two fold of submissions to limb. Kindly have a look your losses rule 5 again. But this is scheme of the act, how the rules, how the disciplinary proceedings to be proceeded with. It's not just a letter of law. It has to be followed strictly, and that too when I have retired. But kindly see the sub-rule 1 of rule 5. The board may authorize any officer not below the rank of a sub-inspector of schools to conduct preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to the misconduct of a teacher of non-teaching staff from the committee or the headmaster, administrator, or headmaster of an institution. Malad, I have two fold of submissions. From here up to first proviso to rule 3. Rule 3, not the proviso, applies to the teaching and non-teaching staff who are in employment. Why I'm telling you, I will explain to your losses there. Now, one submission can be made, my lord, in regard to rule 1. I was the head of the institution. So I will not make any complaint against myself. So, my lord, rule doesn't stop here. Rule say from the committee or the administrator or the head of the institution. So far the head of the institution is concerned.
Where?
My lord, sub-rule 1.
The board may authorize any officer not below the rank of a sub-inspector of schools
to conduct
preliminary investigation
against any teacher
or
non-teaching staff upon receipt of a complaint pertaining to the misconduct of a teacher and non-teaching staff from the committee or the administrator or head of institution.
So this committee means the managing committee.
Exactly.
The administrator, if appointed,
or head of institution.
Now, head of the institution, let us say that he himself should not write against himself. Then also
the
committee is there. No, that's the first question I asked. That you were not there. Your junior was there. The first question I asked Mr. Shumonde, that what did the committee do before the retirement?
That's why the committee rule is, legislature is conscious of that. If the allegations is against the headmaster, who will cat? That's something somebody will do. That's why the committee.
I asked that. Even without looking at it, I asked it.
You didn't do it. Complaint was lodged.
Because managing committee of a school is the guardian of the school.
So for administrative affairs.
Absolutely. So without a managing committee, a school cannot run. So be it managing committee, be it administrator, whatever the nomenclature.
Here, my lord, kindly, my lord, bear in your losses mind that everything, even the complaint by the teacher in charge, I will tell you losses why the teacher in charge did it. Because this teacher in charge was not initially nominated by the managing committee. Managing committee nominated someone else.
Not required to be gone into.
But they are saying, they must kindly see the malafide in it. After my retirement. Then your losses kindly see. Rule 2. If the preliminary investigation report reveals prima facie a case of misconduct, the board shall issue show cause notice to the concerned teacher or non-teaching staff against whom the complaint has been made in order to enable him to explain his act or omission in question by such date as may be specified in the show cause notice. Well, that's why I have taken you 2009 and 10 page. Even before show cause, they asked for a prior approval. But without getting prior approval, they issued the show cause notice.
Yes, yes. Once again, repeat. You have shown me the letter seeking prior approval, but there is no letter granting approval.
But show cause notice was issued. One argument can be made that that's not the initiation of disciplinary proceedings. Show cause. So without permission, I issued the show cause.
But on the basis of that charge sheet was issued.
That's your losses.
So ultimately it relates back to the
that's my point. That's point. Even then you should have stopped there. You could not have entangled me with this document.
You should not have gone for the disciplinary proceeding on the basis of that charge sheet. That charge sheet.
Now, then you also rule 3. If the explanation in reply to the show cause notice is not satisfactory, the disciplinary authority shall initiate disciplinary proceedings against the concerned teacher or non-teaching staff. Malad, I tell you, lordships, I didn't reply to the show cause because according to me, this was thoroughly without authority and jurisdiction. You cannot do it. Then, provided that no disciplinary proceedings shall be initiated after 3 years from the date of alleged misconduct becomes known to the board. However, the shade period may be extended with the approval of the state government in appropriate cases. But why this embargo or impediment? There are 2 classes here.
No, one second.
First one, after 3 years, you cannot.
Even if with the approval.
Now, your lawsuits will find even fundamental service rules, 4 years. If I am not wrong, 56. For the central government employees. State government employees, part 1 and part 2 of the service rules. Every rules, this contains these provisions. There is some logic. So that if you as an employer cannot initiate a proceedings within a reasonable period of time, after retirement, you cannot stop. He has to rest in peace in his retired life. That's the logic, my lord.
No, perhaps that logic I have given
exactly.
in my own way, in the order.
Then your losses second proviso. Provided further that in case of retired teaching or non-teaching staff, disciplinary proceedings may, with the approval of the state government, be instituted within 3 years from the date of retirement, if the misconduct becomes known to the board after retirement. According to both of my learned friends, this provision has been introduced to deal with a teacher like me. That's if I borrow their language. That's teacher like me.
A retired teacher.
Retired teacher. Now, your lordships, with the approval, you have no jurisdiction to initiate unless you have the approval. Kindly see.
No, another second limb. One is approval. Second is, if the misconduct becomes known to the board after return.
Well, that's the complaint letter of the teacher in charge after my retirement.
But will it not require any recording of satisfaction?
That's the other point. Nowhere your lordships will find it.
A recording of satisfaction
lordship,
that yes, I have received this letter. Prima facie, the board must inform, prima facie, I am satisfied.
And your lordships, when the state government will give approval in an appropriate case.
Application of mine.
Exactly. Application of mine will be appearing from the letter itself that I am satisfied.
Later issuing approval.
Exactly, your lordship.
Granting approval will show the reflection of application of mine. Has to.
So this is the first part of it. And second part, sub rule 6. Because 3 years was going to expire. State didn't give the approval. At the behest of someone else, you issued the charge sheet. Without statement of imputation of misconduct, without list of documents, without list of
witness.
Nothing. And all the charges, one line, your lordships. Everybody can make against anybody. Anybody can make against me that I have misapproved the bar association's money if I am a shareholder of the bar association. But that doesn't the charge sheet. There are judgments, of course, old judgment. Nowadays, new judgments. I tell your lordships, one judgment, I appreciate your lordships. I will tell your lordships subsequently. I am dealing with that, your lordships, in another matter of your lordships judgment that so-cause notice cannot be questioned. Uniform. That's the your lordships, not exclusive judgment. Even the Supreme Court says, if there is a without jurisdiction, so-cause notice, I can question. Goes to the root. Your lordships has nicely dealt with it. But I was searching that judgment, very recent judgment. Now, here your lordships, can you have a look at this? Here your lordships, one line charge sheet. Misappropriated midday meal. Now, I, in my capacity, because I am dealing with this type of cases very often, I advise most of the headmaster, please file an appropriate case against the state that being the headmaster, I am the academic head. I am not the head to distribute food amongst the students. There's somebody else's might be there by the government. Because every headmaster nowadays is foisted with the allegation of misappropriation of money with the midmeal. What they are doing, your losses? Those who are not students, that I have to feed them. I am not a local pradhan. And when do this at the behest of someone else, that person is removed, new person comes, he makes, how did you do it? Look it. I have to run the school. But no headmaster moves a writ petition questioning that I am the academic head. You question me if I do not discharge academically my function. This is administrative job. This should be done by the president. Nominated presidents are there who are political persons. Let them do it. Why should I be charged with misappropriation of money after being a headmaster? Well, headmasters is a very reputed post in the even today. We have lost those fragments of the headmaster. But anybody and everybody, a teacher in charge makes an allegation against the headmaster. Now, you lordship, therefore, kindly see why this was done. My explanation and submission to the lordship. Hurriedly, this was done to cover up the time without considering the law that this cannot be done because I have not yet received the approval. This is the first thing, and your lordship's judgment deals with that. So there is no apparent on the face of the record of your lordship's judgment. Review can be done only on that. I will take your lordship lastly to the grounds of a review. This is one thing. Now the second thing, your lordships kindly have a look at this. They are saying that I issued the so-called my lord, my lord, the no liability certificate. Lord, your lordships kindly will look at page 75 of this bunch. Otherwise, your lordships, probably your lordships, this is review.
No liability.
No liability. All that.
Which page you have shown me?
That is page 131 of my can application.
Our my number, tell me.
100. RVW 100 of 20.
131.
131.
Just a minute. I give it. We'll take it.
And another copy was annexed to the writ petition itself, that is page 84.
ঠিক আছে আমি তো কোথাও পাচ্ছি না গো তোমার কোনটা
130
জাস্ট হ্যাভ এ লুক এট ইট তোমার 131 টা দেখাও
The review 100.
Page 130.
আপনার detail যেটা আছে সেটা page 86
না না বাবা এই যে আমরা এখানে অ্যানেক্স করেছি হ্যাঁ দেখছি মানে কাইন্ডলি ইওর লর্ডশিপ টেক আপ দি
Which page? Which page?
Page 84, your lordship will find the
Writ petition.
of the RBW 100 can 1.
Page 84.
84. That is the annexure of their writ petition.
All right.
And page
RBW 100.
Yes.
RBW 100, page 84.
84. Their copy and my copy is 130.
Are,
No, there is some changes are there. There is some overwritten things in page 84, and mine is a printout of the soft copy. Your lordship will find there are minor changes.
So you tell me which page I will look at.
131.
Huh?
131.
131, Mr.
Yes,
Sanyal.
I get. Now your losses can have a look at first 80 of this application.
Huh?
80.
It's the same document.
Not same document.
Eight zero.
80 only.
Kunta, RV?
Can your lordships? Can 2. Can 2 up?
No, RV.
RB টা দেখা ওটাতে আমি 300 RB আমি তো এটা গুলিয়ে যাচ্ছে আমার কাছে দেখো
আমারও গুলিয়ে যাচ্ছে
এই যে RB 100 আচ্ছা 100 তো নয় আমাদের RB তে কত আরেকটা ডকুমেন্টস বললে তুমি
131.
131 এটা তো 131 আরেকটা 84 Now kindly come to first 8 I am taking assistance of my learned friend 84
এটা স্যার স্ট্যাম্পটা মেরেছে সেই জন্য যেহেতু
না আদাও না
Yes.
84
of
that malad
RBW 100.
RBW 100 135 বাদ করো
Yes.
No liability certificate. Liability or no liability certificate. Last date of service, right hand column, 30th October 2019. But kindly see the bottom of
No,
it.
acting, tell me what is the difference between the two?
I'm coming to that. I just place it. I will.
No, I'm just for my.
According to them, I Malad submitted the no liability certificate. It's not that. I'm showing to you now. No liability certificate. Kindly see the bottom.
President.
Contents of
President.
Kindly see the typed copy first. Signature of the head institution / administrator.
Wait. কোথায়?
Bottom of it. Signature typed, your lordships, not stamped. Over the typed. Yes, your lord. Right hand side. Orun Goho. Just below said Alok B. Kumar. Then your signature of the head of the institution.
Shamol.
No, signature of the Samol Kanti, that stamp. Below the stamp. Signature of the head of the institution / administrator / appointing authority. Normally, no objection certificate is issued in respect of teaching and non-teaching staff by the headmaster, being the head of the institution. It can be issued by the
managing
committee by the president. Here, headmaster is the having the asking for no objection certificate. So
yes, the headmaster is asking for no objection, and he being the delinquent, it ought to have been done by president.
This was done by the president. Kindly see the left hand side. Taken the charge from Alok Kumar Mollik, ex-headmaster on 7th November 2019, Orun Guo, President. This is the original no liability certificate. Kindly come to page 131.
Of the same bunch.
Same bunch. Kindly have a look at only that portion. Authenticated and secured through DCS/OTP by Alok Kumar Mollik. Well, everything nowadays to be submitted before retirement, just on the day of retirement, just before retirement. I will show the other documents. Now, this is being done by the headmaster. So he did it. This is the submission of online documents.
Who did it?
Headmaster.
Means your client.
My client. Because he has to deal with it. President will not come and do it. So I, being the head of the institute, I did it. So original documents is page 84, and this is only the online copies goes.
Content is same.
Content is the same. Can you look at this? No variation.
No, একটা জিনিস দেখো, just see, look at one thing. This to be issued by the district inspector, part 2.
Part 2 to be
Part
issued.
2 is not there at
That's
84.
part 2 cannot be, because this will be signed by the government now. This is the original one issued in this format. After getting this, everything is done through online. So this document they are having.
Which document?
Page 84.
Acha.
This is also part of my writ petition. They are saying 131 of part of it. Both I am giving. I have nothing to hide. Why I am saying the kindly see everything was done by me. Kindly come to your lordship page 80 onwards. This has to be done by every employee who is going to retire. Normal rule is before 6 months.
Before 6
months. Normal rule, any government service.
Any government.
Any government service.
In our case also.
Yeah, everywhere the law things. So that on the day of the retirement, the employer comes with folded hand, say, and this is your retirement benefits. You have served well. This is the law, my lord. Kindly have a look at page 8.
If you want to take water, you ask your clerk to bring.
No, this is not.
No, you are free to.
No, that's
take water.
Can you see page 80?
80?
80. I will show some documents, then I will continue. This is, my lord, in regard to withdrawal, submission of papers regards final withdrawal of PF fund. Our retirement date jano koto? First, last 30th September.
Petitioner's name is?
Alok Kumar Mollik.
Alok.
For Alok. 31st October 2019. Kindly see, this was proceeded by the headmaster, signed by me, bottom, before my retirement, 1.5 months before. Then your losses, kindly see page 81.
Why are these requirements?
I am showing your losses. They are trying to create, my lord,
Sir, all these facts I will not
doubt in the mind of the court. That I want to discuss.
I will not go into this in exercise of my power under review.
That's it. Now your losses straightway come to your losses review application.
This is the review application.
Memo of review. I'm sorry. The grounds of review. Oh, Malad, only one thing. Kindly excuse me. That Malad, only one. Have a look. I placed it when I Malad argued this matter. I distinctly remember in courtroom number 23 or something like that. 86. Just have a look at it. 86. It's 100.
Yes, it's a minute.
Well, kindly see.
It's a minute.
Minute, no minute.
86 in my copy, it's a minute.
ও এটা কি ও তাহলে তো এটা হবে না এতে নেই এতে আছে বলো স্যার আমি ওদের সাহায্য নিতে হচ্ছে না হ্যাঁ চার্জ পেজ 90 মাইল
অফ
100 কই পাচ্ছি না তো 90 নয় ডট সেমিশন মিলবে কি নাকি 90
Yes, handover of charge.
Kindly see who took over the charge from me. Kindly see another teacher in charge and the president. President appointed another teacher in charge and the president himself. I, Arun Guo, president, from taking the charge from Dr. Alok Kumar, ex-headmaster, and also handed over the same to Debashish Chakraborty as TIC.
Devashish is signed in the video, bottom left-hand side.
So, as regards teacher in charge, there have been a dispute, might be in the managing committee. I am not concerned with that, being an outgoing headmaster. Everything I handed over. All the accounts. Next page, your losses will find the entire accounts I have detailed, page 87. With the balance amount mentioned in each account. This is my duty. This was my duty. I had discharged.
Next.
Next, my lord, memo of appeal. If a memo of review. Yes. For the first ground, error apparent on the face of the record at the time of the disposing of the writ petition, the Honorable Court overlooked the specific case made out on behalf of the review applicant.
Ground number.
Ground number 1.
For that the order under review suffers from error apparent on the face of record. Since the time of disposing of the writ petition, the Honorable Court, yes, now read on.
No, overlooked the specific case made out on behalf of the present review applicant in their affidavit in opposition, that since the petitioner was the headmaster of 2003 till the date of his retirement, October 2019, and only after his retirement and handing over the charge, it came to the knowledge of the school authority regarding various illegalities of the said petitioner. Up to this, your losses recorded in your losses judgment. Thereafter raised complaints, and accordingly the petitioner is not entitled to pension during pendency of criminal proceedings. This was not during my lifetime
proceeding.
Again, the teacher in charge lodged a criminal proceeding against me for defalcation of money. That's not mine.
After retirement.
After retirement. But this is the way now. Almost 20 to 30% headmaster are facing like this. After retirement, I will show another law. Then your loss is no objection. They have sent, they have withdrawn, illegally withdrawn. You cannot. After my retirement. That's the ground number 2 and 3. Third, pendency of disciplinary proceedings. I think I have, according to my little knowledge, I have answered to that. This is not error apparent on the face of the record. Your losses had considered it. And now your losses have been placed the law. They cannot initiate that proceedings. These are the grounds your losses for review. Error. According to me, there is no error first loss to speak of error. এটা কি আনলে গো? ভুলভাল এনেছো।
To show what point?
I tell you, losses. There is a point in the pension scheme. I was not present on that particular day. Otherwise, it was my duty to point out. Provisional pension can be granted if before retirement there is a proceeding against me and that continues after my time. Not regard to initiation of after return.
After return.
That's absolutely wrong. Here, I can show you losses, but that's in the government service. There is the same provision in the pension regular scheme of 1985, which came into effect in 1989.
So bring
that's
at 2 o'clock.
I will show that. That's another they ought to have pointed.
So you conclude then there within 5-10 minutes. Then he will both of them shall reply and I will do whatever.
এটা আমাদের নয়। আরে হেডমাস্টার ম্যানুয়াল আনো তো।
What judgment you were telling?
But I don't require your losses.
No, one judgment you just told me.
Oh, that I take your losses. In a matter regarding grant of auction. Your losses. Show cause a auction purchase, auction was granted to him. The show cause notice that he should be blacklisted, all that. Your losses, the show cause notice was questioned. Show cause was questioned. Now your losses very nicely dealt with it, because often I face with it, both sides. General rule, ordinarily court will not stay the order of show cause or office order show cause unless it goes to the root of the jurisdiction or in exceptional circumstances. Your losses has very nicely dealt with what goes to the root of jurisdiction. That's without authority. Because I'm another case I'm doing it, that I'm citing that. That's your lawsuits, Malad. Otherwise, your lawsuits, state jacket from so cause no, you cannot. As if not the charge sheet. Charge sheet court will not. But if your lawsuit on the face of it, the charge sheet doesn't disclose any misconduct, can I not come before the court? Just like a criminal FIR. If the FIR doesn't disclose an offense, I can come up in the jurisdiction for quashing it, right from the judgment of Justice Honorable Justice Umesh Chandra Banerjee. I can. So that's the point. Like
the division in 482, the basic first principle of law is alike Order 7, Rule 11. On the face of it, whether it discloses charge or not. And if it differs or if it is not sufficient, quashing will apply.
As without authority. Without authority, you the approval of the government.
All right, we will hear. I will hear that. And you conclude within 5-10 minutes, doing whatever you want to show.
That's it.
With the Xerox copy.
It must pension scheme 1985 or year.
Come, we will complete it today. Thank you.
শেষ করে দাও, কতদিন ভদ্রলোক করবেন এটা করে?
Yes.
Well, I have sent for photocopy, but in the meantime, kindly allow me with the books, then I can. Kindly see preliminary. Oh, parer boi. This is, I could have handed up to this book, but this is bulky one. But this is smaller, that's why I have handed up to your lawsuits.
Yes.
Kindly see, this scheme may be called the West Bengal Recognized Non-Government Educational Institution Death Cum Retirement Benefit Scheme 1981. Then 3. These schemes shall apply to employees of the state government sponsored or aided educational institutions, including delegating schools, as indicated above, who were in service on 1st April 1981, and also to those who were appointed after that, the date, provided they draw salary. Well, this is the application. Therefore, I am governed by this pension scheme, aided institution, all that. Now, I will show you also 2 provisions out of this. But kindly come to clause 8 of the scheme, eligibility of pensions. Kindly see, madam. Subject to satisfactory service, an employee shall be entitled to pension, provided that in case of Roman 1, Roman 3, and Roman 4 below, the employee concerned has completed at least 10 years of qualifying service. Roman 1, on attaining the age of superannuation. Up to this, Malak, I am confined. 2 things, subject to satisfactory service and on attaining the age of superannuation. I attain
And 10 years.
10 years. All these 3, my lord, on the 31st October 2019, I complied with. So I became entitled to pension on the date of my retirement, on attaining. This is the law, my lord. On the last day, my right crystallized. Then your losses kindly come to clause 15. I'm sorry, my lord, clause 19. I will be a loss of sub rule 5 or clause 5. It's not rule, my lord, scheme. Has you also got that one?
1 second.
19.5.
Then sub rule
5. This should be clause.
sub rule 5 to
Rule 19. 190. Rate of pension under the heading rate of pension.
16 is rate of pension.
17, 18, 19.
19.5. Yes.
Final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental/judicial proceedings have been instituted and or / continued. Then, in case of misconduct of the pensioner, the pension sanctioning authority has the power to withhold pension or reduce the pension. Different. Now, where any departmental or judicial proceedings is instituted, or where a departmental proceedings is continued against an employee who has retired on the attaining age of compulsory retirement, on attaining the age of compulsory retirement or otherwise, shall be paid during the period commencing from the date of his retirement to the date upon which, upon conclusion of such proceedings, final order is passed, a provisional pension, not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the diploma. Like this is entirely, my lord, if the proceedings is pending during my service, not after retirement. It doesn't take into, my lord, cognizance the subsequent proceedings. Because if I read with rule 8, this rule, kindly see, your lordship, what department is instituted or what department is continued against an employee who has retired on the agreement. If I go, my lord, between the lines,
if the proceeding is instituted, where any departmental judicial proceeding is instituted, or where a departmental proceeding is continued against an employee who has retired on attaining majority.
Compulsory retirement or the other.
So when departmental or judicial proceeding is instituted against an employee who has retired on attaining.
So entire thing contemplates that if it is instituted during
has to be a prior institution at the prior to retirement.
Because on the date of my attaining, I accrued that pensionary right that was not instituted. So this cannot be. Provisional pension contemplates for those employees who are, my lord, under disciplinary proceedings
but retired,
or under judicial proceedings during the employment.
And here also I have delivered one judgment that this proceeding, that's a different point. Proceeding has to be a nexus and connection with his employment.
That's with this service.
That's a different issue.
Kindly see, this cannot be applied. It's omnibus, not omnibus provision. Anywhere you can apply. It's not. Suppose, Malad, after that's why, Malad, the limitation also in the rules. 2 years with why that stringent? Because these are under managing committee. These are not the government authorities as such. Personal vendetta can play. So that's why government puts a restriction on them. That give me, take my approval before doing that. So, if this is I'm showing because of provisional pension, Your Lordship, first 20. This is not, I'm entitled to full pension, irrespective of dependency or not. The first point, this is nothing pendants. This is absolutely non-est. So this is my submission to you. Well, may I take a losses leave?
Thank you.
I say, Your Lordship, first and foremost, this is a review application. This is a review application. The scope is very limited. Your Lordship, I have to satisfy Your Lordship that there is any error apparent on the face of
No,
the
no, you
record.
first satisfy me that
But
you
there is
obtained the sanction.
Yes, Your Lordship, I have. This was not necessary for the adjudication of the review application because the disciplinary proceeding was not being challenged.
No.
It has not been challenged till date.
Therefore, first is that there is no apparent error.
Yes.
Just because you did not file affidavit, it was kept ready and lying with your file. That's no ground for review.
Lordship, the maintainability, in my respectful submission, the maintainability of the review application, Your Lordship was satisfied that this was maintainable and directed them to file their affidavit.
No.
That is my humble understanding in this.
Even after affidavit, I can say not
Your
maintainable.
Lordship can. I am just making my submissions that in my respectful submission and humble understanding that this was what is false. Now, with regard to approval, there was an approval.
Sir, again, I will not take anything which is not on record. I cannot.
That is there, Your Lordship.
No, I cannot in the review stage.
Because all the documents which I have relied upon, Your Lordship, because this was not the this was not necessary for the petition. It is only
the honorable just on that verdictum I have read yesterday. The Supreme Court has come up with a finding that no evidence should be relied upon in a court unless it is supported by pleading and in part of the pleading.
Your Lordship, I make this submission that the writ petition
দেবাশিসকে একবার বলো তো কালকে আমি মেল দিয়েছি ওই মেলের ড্রাফট কাগজে প্রিন্ট আউট দিতে দুটো জাজমেন্ট মেল করেছে, একটা সুপ্রিম কোর্ট একটা মাদ্রাস হাইকোর্ট।
My respectful submission is that there was a due approval because whatever submission has been made on
It
behalf
was
of the
never in the record of the writ petition, neither in review.
because the disciplinary proceeding was never challenged.
Not required.
Yes, I also say that the disciplinary proceeding, your lordship need not go into that because that was never challenged. That has not been challenged before any forum. So far my knowledge goes, your lordship, the writ petition was filed for disbursement of retirement benefits. We in our opposition, we have stated that it is not on record. But
If I say that at this stage they have argued that no sanction is there in absence of any sanction, and which is not part of the record. So I don't find any sanction. Had there been no sanction, the process itself is an honest. Therefore, there is no further question to be gone into with the writ
Your
petition.
lordship kindly considers this, the disciplinary proceeding is the prerogative of the board. Board was never made a party to the writ proceeding.
Not required.
No, it is required because they were aware that there was a show
I
cause.
don't say I cannot say my order is free from any error. I will say it is not a reviewable order.
Why it is
Proceeding
so?
for review will not lie.
Your lordship, may I kindly make this reiterate my submission that the only point for which we came up in review was that your lordship had directed payment of entire retirement benefits along with gratuity, and my humble submission is that under the circumstances, since it was informed to your lordship that there was a charge sheet pending, whether right or wrong, during pendency of the disciplinary proceeding, the petitioner was entitled to provisional pension and nothing more. The provident fund has already been disbursed. He was not entitled to the entire retirement benefits, only the provisional pension he was entitled to. That is the
Now let me come to my order. What did I say on this?
Yes, your lordship. Kindly
see my orders. Page.
With regard to the charge sheet portion where your lordship has observed.
No, review first.
Yes,
my order. My order dated of review.
22nd, which is
22nd February.
February 2024.
Yes.
Lordship,
why I said that give everything. Hey, to pakada komi dao na. Why have I said?
Yes, your lordship kindly takes up the last paragraph at page 138.
No. Review. The order under review.
Yes, I am placing that. Page 138, your lordship kindly.
Internal page?
3.
I am on RBW 100.
Yes, your lordship. The memo your lordship is taking up. I am placing from the stay application.
Stay application.
If your lordship kindly takes up internal page 3, that will. Internal page 3, the last paragraph.
Yes, sir.
Shonojit Kumar Ghosh. The lordship has got it. Mr. Shonojit Kumar Ghosh, learned counsel for the petitioner led by Mr. Sannal, submits that from the affidavit in opposition, though the original is not on record, but the affidavit in reply filed on behalf of the petitioner thereto is on record, it appears that a purported charge sheet was enclosed in the affidavit in opposition dated April 21, 2022. Since neither the school authority has been represented nor the state has been represented, no submission was made on the basis of the said alleged charge sheet. No sustainable material or ground is available before this court in support of the said alleged complaint lodged or charge sheet issued against the petitioner. This was your lordship's finding. So that was my contention, humble submission, your lordship, that since your lordship was drawn to this observation and this finding that a charge sheet is there, good but indifferent, my respectful submission was that your lordship ought to have granted provisional pension instead of the entire retirement benefit. That is the only scope of my review application. I have not said anything more. In my first round of submission also, your lordship, I have kept my submission, restricted my submission to that aspect. Now, I say since it fell from Mr. Sannal that he is challenging, he is submitting that the entire disciplinary proceeding is non-est, because that was not never the contention of the writ petition or the review application, or the order was passed in that respect. So now since this has fallen from Mr.
Okay,
Sannal,
you kindly come and read my observations after considering.
yes, in view of the page 5.
After considering the kindly come to 130, ne? After
139.
considering the submissions made on behalf
Yes,
of the
yes.
petitioner,
And on perusal of the
perusal
materials of
material,
record.
it appears to this court that admittedly the alleged charge sheet was disclosed for the first time through the affidavit in opposition. Right? And 3 years, after 3 years of retirement of the petitioner. An alleged complaint dated October 1, 2019 to the petition was lodged few days prior to the retirement of the petitioner by one such and such, who is acting as the teacher in charge of the relevant school since after the retirement of the petitioner, as submitted by the learned counsel for the petitioner before this court. It was also submitted that Sri Tanmoy Vishwas was the material time as the assistant teacher and a colleague of the petitioner during the employment tenure of the petitioner, but no such complaint was ever lodged. Record shows that the managing committee of the school took over charge from the petitioner when he retired as headmaster without any objection or demand. No disciplinary proceeding was initiated against the petitioner during his employment. The petitioner had an unblemished career record at all material time. The petitioner has rendered his service for 32 years. In view of the above discussions, found view that there is no scope for any reason as to why the petitioner shall not immediately be released and paid with all his retirement benefits. Right. Now, charge sheet is taken, admittedly. If I find today on review that this charge sheet does not disclose any approval, neither the disciplinary proceeding, right, what he has argued today, right? Therefore, there is no error on the face of it. Because had that been on record, then there would have been an error on the face of it.
Charge sheet, in my respectful submission, Your Lordship, since although it is my fault on that day, I was not there, Your Lordship. But since it was brought to the notice of Your Lordship, in my respectful submission, Your Lordship ought to have, because that is why I have filed this.
Ought to have, but I equally ought to have weighed the charge sheet, that whether it was in accordance with law or not.
But that was not the scope of the writ petition, Your Lordship.
Of course.
That was only, Your Lordship was not, in my respectful submission, Your Lordship is till date not sitting on the veracity of the charge sheet, whether it is valid or not. Your Lordship is not concerned with that. Your Lordship, while deciding whether the petitioner is entitled to the retirement benefits, Your Lordship is to see
whether any charge sheet is there or
not. Whether a disciplinary proceeding is there. Suppose on that day I was there, Your Lordship, proper submissions would have been made. Your Lordship need not go into the veracity, whether it was filed in time. Maybe if there was a bar to limitation, Your Lordship could have. But prima facie, there is no bar to limitation. There is a provision that we can do this within 3 years. And
I again say
prima facie,
that
Your Lordship,
on the face of the materials available before me.
Yes.
There no error suffers.
Yes.
So therefore, review will not lie. Review will not lie.
Your Lordship,
you might question the correctness of this order in appeal.
No, since the charge sheet is there, and Your Lordship did not go into the merits of the charge sheet, my respectful submission was that Your Lordship could have restricted the order to the provisional pension, because during a pendency of a disciplinary proceeding.
At the same time, while the charge sheet, let's go back to the writ petition stage. Charge sheet is there, but there was no material in support the charge sheet was issued upon prior approval of the state. That was not there on that day.
Not needed. In my respectful submission, your lordship need not go, because until and unless the disciplinary proceeding is called into question, unless there is a proper institution of a proceeding challenging the disciplinary proceeding, your lordship
An
need not.
employee has served for 32 years, and if the material is not there, that approval was there.
Your lordship kindly sees the annexures to their writ petition.
Show me the writ petition.
Yes, that is annexed. Before that,
No, show me the writ petition once. Are you
yes,
carrying?
that is annexed to the stay application. I'm placing it.
Show me the prayer from the writ petition.
Kindly, please. Page 52, it starts.
Page
52.
No. What is 120?
120. This is the subsequent application they had filed against the show cause notice. Against the show cause notice.
That contains a prayer. Set aside and quash the show cause notice.
Yes, that is 1st October 2021. That is a different thing.
No, but that was there when I decided the writ petition.
Yes, but
so that is sufficient.
No, that is with regard to the show cause notice, nothing with regard to the charge
show
sheet.
cause notice, correct, but show cause notice flows from what? If you don't have the approval?
But your lordship has, in your lordship's order, has not set aside that.
Absolutely not. I did not. I did not. But I can take that point. I can discuss that the application says this.
The lordship, in my respectful submission, never went into the merits of the show cause notice and the charge sheet.
But today, question is of review.
Yes.
So I have to come to, if I come to a conclusion and my finding that there is no error apparent on the face of it, your review will not lie. You might have a ground for challenging appeal.
I understand. Whatever falls from
you might have a grounds for appeal, but review will not lie.
Lordship, kindly sees page 53. I'm placing the relief spread in the writ petition.
Yes.
Read and page 52 it starts. Page 53, respondent authorities and their main agents to disburse all retirement and service benefit of the petitioner, including provident fund, gratuity, leave encashment, salary, pension, and all other dues in favor of the petitioner forthwith, along with interest at the rate of 18%. B. Read in the nature of mandamus directing the respondent's authorities and their main agents to forthwith issue no liability certificate in favor of the petitioner. So that is there. Now C, read in the nature of mandamus directing the respondent authorities and their main agents to set aside and or quash the show cause notice dated 13th November 2019. Annexure key 10 to the instant writ petition.
Sufficient.
During 13th November 2019, the approval was not required. Only for initiation of a disciplinary proceeding, the approval is required.
The moment you are issuing a show cause,
I can
on the charge.
Not on the charge, on a preliminary investigation and on the basis of a complaint. Show cause can be initiated. Only when the charge sheet has to be initiated,
you're correct.
Then I have to obtain an approval, and that was there, although not on the record, because that was never the issue involved. D, a writ in the nature of certiorari directing the respondent authorities to transmit all the relevant records pertaining to the issue.
All right.
E, F is an interim order. So Lordship kindly considers their own statement. If your Lordship kindly sees the application which they had subsequently filed, I'll be placing short portion of that. Your Lordship kindly sees page 118. The subsequent application which they had filed, where the prayer for cancellation of the show cause was there. Prayer, paragraph 25.
Yes.
The second proviso of the rule 5.3 provided that in case of retired teaching or non-teaching staff, disciplinary proceeding may, with the approval of the state government, be instituted within 3 years from the date of retirement if the misconduct becomes known to the board after retirement. 26. In the instant case of your petitioner, said purported inspection was held on 1st November 2019 and accordingly said purported report of inspection upon holding the alleged misconduct of your petitioner was submitted on 1st November 2019. That is after retirement of your petitioner from the service, and as such, the second proviso would be applicable in case of your petitioner. That is their own statement. They
Second
say that the
proviso
second
means
proviso is
approval.
yes. And that approval, your lordship, now they say your petitioner further submits that on basis of the said purported inquiry and report thereon, upon holding misconduct of your petitioner dated 1st November 2019, the said purported notice to show cause was issued by the board on 1st October 2021. But in spite of non-reply on the end of your petitioner, no disciplinary proceeding was started upon invoking Rule 5.3 of the said gazetted notification within 3 years from the date of retirement.
Sufficient.
But it was sent. It was sent. The charge sheet was filed on 22nd of April 2022. This application is being affirmed in 2023. Having sufficient knowledge, this was never placed on record. It was in our opposition. We say that the charge sheet is already there and the disciplinary proceeding is also being carrying on. And that was by the approval of the commissioner. Due approval of the commissioner was granted. Now, your lordship will kindly consider this, that the petitioner retired in October 2019, 31st of October 2019. The inquiry report was given on 1st of November 2019. And immediately thereafter, your lordship will find that the letter which Mr. Shannal placed, that the board had requested for an approval from the commissioner, it was of March 2020. No, I am mistaken, January 2020. Now, your lordship will kindly remember from March 2020 to entire 2020, there was a complete lockdown, almost, your lordship. Now, this was given in September 2021.
Not required, not
No,
required.
that-
I am on review. These facts are not
My
required.
lord,
Ashok.
may I
These facts are
may I place my lord my with, if yes. My lord, first of all, I shall just beg to repeat one thing, my lord, that petitioner is altogether challenging, putting a challenge to the disciplinary proceeding initiated against him in our review, which he cannot. Appropriate authority.
I'm not even dealing with his plea.
May I just within my lord, within 5 to 10 minutes,
So
I shall.
review, ground for review is there.
Yes.
On the basis of the available material as on that date when I passed the order.
My lord. My ground, may I just place the grounds of RVW 298.
The moment I say in my order,
I shall try to apprise your lordships in my way, my lord. Kindly bear me for some few minutes.
Yes.
Yes. Ground one, very short, my lord. Within 6-7 grounds, I have, my lord, tried to. That the order under review suffers from error apparent on the face of record, since at the time of disposing of the aforesaid writ petition, the Honorable Court, my lord, says same line, my lord, overlooked the important fact to the effect that since the petitioner respondent was the headmaster from this to this period, and only after his retirement, when he handed over charge, it came to the knowledge of the school authority regarding various illegalities of the said petitioner, and thereafter he raised complaints before the appropriate authorities, and accordingly the petition is not entitled to pension. Why, my lord? The managing committee is headed by two persons, president and the secretary. Secretary is the headmaster himself, according to the law. So during his president, the tenure of a headmaster is all in one in the school. For certain few instances, he takes the concurrence of the president.
I'm again saying, Mr. Dey, that you might have a good ground for appeal, but not on review.
Since my lord was not properly apprised about the proposition of law while my lord passed this order, particularly Rule 5.3 of the 2018 Discipline and Conduct Rules. My lord was altogether, it was tried to be portrayed before lordships that After retirement, each and everything what has been initiated is vitiated, is not backed by law. Problem is, my lord, in review, we cannot, my lord, in that way. Only we can make submission that these are might be the situation, my lord, may modify my lord's order. We cannot put challenge directly with deepest of respect. Now, nature of allegation, this no objection, the German is that no objection certificate. How Mr. Chatterjee has already, my lord, appraised your lordships, how the petitioner himself procured the NOC through the president during his tenure by using which he cannot. Whatever has been observed by your lordships is not backed by any resolution of the school managing committee. My lord, kindly comes to the
Mr. Dey, again, I cannot take those on review. You might.
No, my lord has observed that certain things this has been supported by documents that the necessary, my lord, page 2 of your lordship's order, may I read, the necessary clearance and online acknowledgement is available at page 56 of the writ application. On June 3, 2019, the school, through its headmaster, submitted the final pension file for pension in favor of the petitioner. This, my lord, I say, my lord, the headmaster himself cannot do it itself, has to be backed by the resolution of the managing committee.
I cannot reopen the facts on review. Kindly come to page 4 of my order.
My lord.
And now read from after considering. Your review will lie with regard to my finding, not on the submissions.
Not on the submissions.
On my finding. You show me, you read from after considering the submissions. Read it. Internal page 4.
After considering the submission made on behalf of the petitioner and on perusal of the materials on record.
So on perusal of the materials on record.
My lord. It appears to this court that admittedly the alleged charge sheet was disclosed for the first time through the said affidavit in opposition after 3 years of retirement of the petitioner.
No challenge to that.
Which is not correct.
Not correct. That I don't know. On that day.
That is the thing, my lord. But it was the duty of the petitioner to apprise that he, prior to 3 years, he has got to know about this charge sheet.
Sir, that is neither here nor there, because it is your duty to come and say, tell the court. It was not done. So on the basis of available material, what finding I have come?
Yes, but we, rightly, my lord, we missed that chance that at the time of passing of the order, but here.
Then read on an alleged complaint.
An alleged complaint dated October 1, 2019, Annexure P, page 66 to the writ petition was lodged few days prior to the retirement of the petitioner. So prior to the writ petitioner, and the judicial proceeding has been initiated by one Tanmoy Biswas, who is acting as the teacher in charge of the relevant school since after the retirement of the petitioner, as submitted by the learned counsel for the petitioner before this court. It was also submitted that Sri Tanmoy Biswas was at material point of time an assistant teacher and a colleague of the petitioner during the employment tenure of the petitioner, but no such complaint was ever raised against the petitioner prior thereto.
So these facts are there before me.
Yes.
On that day.
Yes.
No, without any controverting material. Because you have to judge the order of review as on that date. What was there?
Yes.
Right. So these were there. So I came to this finding on the basis of the materials which were there on that day.
My lord.
Yes. Record shows.
Record shows that the managing committee of the school duly took over the charge from the petitioner when he retired as headmaster without any objection or demand.
This was no controverting material was there.
That is the thing, my lord, with deepest of respect. Here, there is a controverted record. The part of the record which was not correct was placed before lordship, and it is now our duty to put the correct record before lordships. This part we have specific answer to this.
To put the correct record before your lordship, before me today, which means a new records you will bring?
Already, my lord, part of the review application.
Part of review, but new record.
Yes.
As on that date of order.
Yes.
When those records were not there before me, I passed this order. Now subsequently you bring those records through review application. Right. That in my view cannot be a ground for review.
If, my lord, a palpable illegality, misusing the power, if it is brought before the honorable court, can the honorable court, my lord, I am putting this question to myself, that when the larger interest of the students and at a government sponsored school has been hampered, my lord, would be, my lord, my humble submission, my lord, maybe, my lord, be pleased to look into that aspect also.
Not in
because
review.
It is,
you can reopen the entire case in appeal. Again, I am saying.
Yes.
Entire case you can reopen in appeal. It's a continuation of the proceeding.
But what will happen,
review,
my lord?
No.
Since proper, my lord, record was not, my lord, put before lordships.
That's
the
you
charge
have missed your
sheet.
bus. You have missed your bus. That cannot be a ground for review.
No, since my lord kindly sees one thing, my lord, kindly, my lord has directed altogether, my lord, I have repeating that situation was tried to be portrayed that everything was started, my lord, after retirement, which is not tenable, which we say under the law, it is absolutely permissible. The appropriate law of 2018 was not brought before your lordships. What it says, my lord, may I once again, my lord, come to, my lord, rely on this 2018 rule.
Sir, I accept your proposition. You show me as on that date of order, when the order was passed.
Yes.
These were there before me and I have not considered. Then only it is an error apparent on the face of it. Subsequently, by way of a review application, when you bring so many materials which were not there on that date, not submitted on that date, no ground for review.
My lord, the point of this initiation of disciplinary proceeding. Although, my lord, that was not placed before, but it was put to your, my lord's knowledge that a disciplinary proceeding has been started.
Perfect. I have recorded that.
Yes. Now, pending this disciplinary proceeding, if my lord pass this order of final payment of pension, that would preclude the authority, the appropriate authority to initiate it will create a bar against the disciplinary proceeding to come to a logical conclusion.
That is not the lookout of the court. Why I tell you? Kindly again come. Record shows that after considering the submissions, I said that the disciplinary proceeding would have this disciplinary proceeding as on the date of passing of the order on the basis of the available material could not stand in the way of releasing the full benefit.
My lord has never heard the merit of the disciplinary proceeding.
Absolutely.
Because it can only be supported by the board, which is not the party herein.
I accept, but that is not the ground of review.
But the proceeding has been completely, my lord, will be vitiated by your lordship's order since the authority. Although, my lord, right now, my lord has directed to pay the final pension.
You could have gone for appeal. That this is a wrong order.
At that, my lord, situation will be saying why you have not put the correct record.
Exactly.
Before the
Exactly. But on review, I cannot take those new materials.
But this, another thing, my lord, this NOC part, what my lord has observed, kindly comes to, my lord, page 212 of my stay application. Others, or my lord, what has Mr. Sannal has tried to portray that to obstruct him, he has already an unblemished career. That would reflect from the, if I am not inviting your lordships to this, all these complaints. Complaint has come, just for 1 minute, my lord, just complaint has come from the guardian, from the ex-students from whom.
Where were they before me?
Yes, they were
As
not
on
there.
that date.
That is the thing, my lord. They were not there.
So I
It was,
cannot.
kindly, my lord, come to my lord, page 212.
Page?
The last page of my stay application. Of stay application, my lord, it is can 2 of relating to my lord RVW 298.
Yes, page
212, my lord, the last page of the stay application.
212
My
is
lord, is
not
on,
there. 77, 78, 80.
yeah, can 2 kina? My lord, I quoted it. Is it can 2? Yes. The very last annexure, P9. What the petitioner has obtained through this by misleading or misrepresentation by the then president. This is the letter of the president now, my lord, addressing the DI. Issue of, since no objection certificate following unusual protocol. This is to inform you that, as told by the headmaster, that I shall have to issue no objection certificate as per usual protocol. My lord, issued that has been a teacher and served the school for a long time, but some irregularities was noticed by me and unintentional, and that is why I am requesting you to ignore my previous no objection certificate on perusal. Further, my lord, it is further to mention I am incapable. I am incapable of taking responsibility of the liability of the new building because sorry.
No, now, Mr. Dey,
Now
you
this
show
has
me.
been
Yes, I admit this document.
withdrawn.
So you show me this document was there when I passed this order. You have submitted, make submissions, still then I did not consider.
I have a pleaded specific ground that for which, my lord, the school was, my lord, school could not appear. Fault, whatever fault, my lord. That is why this important document was not part of the record.
School did not appear, chose not to appear, state did not choose to appear.
That is a coincidence. I do not know, my lord, after that, my lord.
That's I don't know.
Even the charge handover proceeding, what Mr. Sannal has, that is also we have, my lord, specific documents. The charge was, who has taken the charge, later finding all this illegality, he has also refused, my lord, page 70.
I say that these are not the grounds for review. You could have taken up an appeal that look here, give me an opportunity because these things are there. This was not, we could not produce. Unless you produce.
But in absence of no liability certificate, it was, my lord, even, my lord, no, just the no liability certificate was itself was, my lord, in suppression or is a procured, my lord, fraudulently, which has been part, my lord, of the record itself, my lord. And
I understand, but how can I enter into a review? An appeal court can take. It's a continuation of the proceeding. It can say.
But only one thing, just lastly, my lord, I will urge, my lord, that when this disciplinary proceeding issue was brought to your lordship's notice, it was not that, my lord, the law says within 3 years of retirement, it can be initiated. And
With the prior approval.
Yes, with the prior approval.
So
Here,
admittedly, on record, there was no prior approval. How could you initiate?
the appropriate authority was not before your lordships. Who could have, it is purportedly, my lord, the appropriate authority being the board, who could have supported this disciplinary proceeding appropriately. We at the school, we have lodged a complaint before the appropriate authority. Now the duty lies on the appropriate authority to initiate. That has been done.
Who asked for the consent? Who asked for approval?
Yes. Page, my lord.
Who asked for the approval? From the state?
This is the board. Page 209.
209.
9.
Who asked for
the disciplinary authority sought for the government as per the law to issue permission. What we could
এটা বের করতে হবে না ওখানে ওখানে ফাইলে আছে তো ফাইলটা শুদ্ধই আমাদের ফাইলটা শুদ্ধ আমাদের বের করবেন না বের করলে হারিয়ে যাবে
yes
ফাইল শুদ্ধ
209 of the stay application. The disciplinary authority maintaining the protocol has sought for permission from the government, from the state. The disciplinary authority seeking permission for initiation of disciplinary proceeding against the Olok, my lord, is on page 209. My lord already has perused it by N. It is of January 2020. This from the Commissioner of School Education, Government West Bengal, the disciplinary authority seeking permission. Pursuant to that, the commissioner has duly granted permission to initiate.
That I didn't know on that day.
That
when the order was passed. That's the difficulty. I didn't know.
Was it? My lord, may I just rely on this
judgment?
Judgment, my lord.
Yes, yes, of course. You're welcome.
Honorable Justice Toproto Chakraborty.
You're welcome.
Yes. It is a very recent, my lord, drawing the attention. Drawing the attention of this court, my lord, this third paragraph, starting
One second.
My lord.
একটা কাজ করো তো
পুরোটাই পড়ছি
এটা গেঁথে হ্যাঁ একটা সাদা ফাইলে ঢুকিয়ে আমায় দাও এটা আমার চেম্বারে কি এটা দিলেন ওনারা yes what is the point sir
yes my lord here my lord appeared Mr. Shokinath Mukherjee my lord drawing attention my lord third paragraph drawing the attention of this court to the order dated 11 January 2017.
Page.
My lord, very fast page, my lord. Third paragraph, starting with drawing the attention of this court to the order dated 11 January 2017. Mr. Mukherjee, learned senior advocate appearing for the applicant writ petitioner, submits that no one appeared on behalf of the writ petitioner on 11 January 2017. And as such, the court was not apprised of the proper facts. By the said order, the writ petition was dismissed primarily on the ground that though the cause of action accrued in 2008, whereby allotment of land in favor of the petitioner was cancelled on 2nd May 2008, the writ petition was, however, filed in the year 2014. Such delay and latches towards preferring it was not found to have been properly. Now, my lord, this
thank you.
Third, if we skip to my lord, third page, second paragraph. He further submits that a registered lease deed cannot be cancelled on the basis of a mere resolution of the board. Such cancellation has to be done by registered deed. The land in respect of which the lease deed was affected is still lying vacant, and the petition is continuing to pay the lease rent. In support of the concern, Mr. Mukherjee.
So, here what happened? A registered lease deed was there.
My lord.
Now, suppose a company by way of a board resolution cancelled, which is not permitted in law.
Yes.
So, ex facie it shows error on the face of it. The deed was there, the cancellation was there before the court.
My lord.
Right?
My lord.
Try to understand.
My lord.
The deed was there. The cancellation was also there by a board resolution.
Absolutely.
So the automatic question whether the cancellation is valid. The law says it is not valid. Fair enough. So materials were there before the court to come to a right decision.
Yes. No.
Here the materials were not there before me.
Here also, my lord, in support of, we have, my lord, missed to file to place on record these documents. In support of such contention, Mr. Mukherjee has placed reliance upon documents which have been brought on record by a supplementary affidavit.
Supplementary affidavit where?
Where, my lord, in the review application?
No, in the writ petition.
In, my lord, cannot be here in support of such contention, Mr.
Kindly
Mukherjee.
see why I tell you.
Here also,
Kindly see the last
Rule
part.
5.3.
Kindly come to page 5.
Yes, page 5, my lord. My lord,
With
prior to
the
that
above
page,
observation and directions, this writ petition is disposed of, not the review.
by a common order, it is a review. My lord, kindly, my lord, under such, my lord, page 4, page 4, second paragraph.
Yes.
Under such circumstances, the order dated 11 January 2017 is recalled. It is in review. And the review application being RVW 101 of 2017 and the application being CAN are disposed of, and the writ petition is taken up for final hearing. So disposing of the review, my lord, writ petition was taken up for hearing. So here also, my lord, we say that law was there so that petitioner cannot be deprived of his provisional for whatever charges, but he cannot, only one way was available for the authority to inflict a proceeding against a retired employee. Only one is to curtail his pension, because here the only one way will be taken out by way of lordship's order. The authority at division which has been initiated, that has
don't travel so much. You first concentrate your submission that the review has to be allowed.
Yes.
If you succeed to that,
my lord,
that review will be allowed. Then, of course, again, affidavit is that fresh hearing of writ petition.
we say, my lord.
So you first sustain your point of review. That review is to be allowed.
We are
don't go on the merit of the writ petition.
No, we are not going, but the review.
Show me the law. That as on that date, whatever material was there, court proceeded, court rightly, wrongly passed an order. Order may be right, order may be wrong. That cannot be tested in review.
No, never, cannot be.
Right?
My lord.
The review application, you have to satisfy that it squarely falls within the grounds under Order 47.
Here, the moot question was that paying of full and final pension and pending this disciplinary proceeding which was brought to your lordship's notice, that was not, my lord, fully gone into the merit. Even if your lordship, my lord, is invited to, my lord, entertain, my lord, to look into the disciplinary, the veracity of the disciplinary proceeding, that has to be, my lord, given a chance. Board has to be heard, my lord, that disciplinary proceeding under what has culminated the situation for the board to initiate the disciplinary proceeding. That chance was never, my lord, given for the discipline, but my lord is touching the disciplinary proceeding part. we order 47 rule 1, my lord, kindly see rule 2. We can seek your lordship's, my lord, intervention in this order. A party who is not appealing from a decree or order may apply for a review of judgment, notwithstanding the pendency of an appeal by some other party, except where the ground of such appeal is common to the applicant and the appellant, or when being respondent, he can present to the appellate court the case on which they applies for the review. On this core, my lord, we are eligible to seek your lordship's, recalling your lordship's order by way of review. On this clause 2, order 47, my lord, on this core, my lord, we are the party to, appropriate party to seek, my lord, your lordship's order in, my lord, to consider in review.
On what ground? Tell me, I'm on order 47 itself.
Yes.
I'm also reading order 47.
Yes. Or by a decision, my lord, C, 1C, my lord, by a decision on a reference on, no, it's not.
উল্টো পাল্টা পড়ছে স্মল কজেস কোডের কি আছে এখানে?
No, that is not, but by clause 2.
Have your breath, go slowly, have your breath. Who knows, you might have a point.
Yes. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but
that's not your case.
Yes, but a party who is not appealing from a decree, my lord, can seek.
Not your case.
There's sufficient reason I can. Need not be error apparent on the face of the record, but for any other reason, sufficient reason I can.
My lord, along with that, on, my lord, it is, my lord, clause C, on account of some mistake or error apparent on the face of record or for any other sufficient reason. There is sufficient reasons that your lordship's, my lord, was not put to, my lord, to decide appropriately, particularly, my lord, rule 5.3.
মাদার বিটে হবে না বাবা, এটা একটু ডেভিলিং করতে হবে।
After this judgment, my lord, this certain documents in Justice Saurabh Chakraborty's order,
একটু পড়াশোনা করতে হবে এটা।
then maybe, my lord, come back.
I don't mind for that. You have to reply.
Ready, man?
You're ready? Yes. Come on, give me the reply. Concentrate on the point of review, right? Don't concentrate, don't make any submissions on the point of merit of the disciplinary proceeding. Yes. Tell me why review should not be entertained. Because you have to say that the review shall not lie. Wait.
When a review is maintainable, my lord, if there is any wrong in the judgment or degree apparent on the face of the record, so their case is this.
Only then.
Their case is this.
Only then.
No, my lord. Other things, if there is any mistake on the part of the learned advocate or like that, but
only then.
That is, those cases are not made out.
Only then.
Only their case is only that the disciplinary proceedings issued by the alleged charge sheet, that was not properly considered. That was the only ground for, and that is, according to them, that is the pending disciplinary proceedings. And my humble and respectful submission, my lord, that was elaborately submitted by my leader, my lord, showing the rule that charge sheet is not at all, my lord, the charge sheet.
Why you challenge that? In the writ petition, you have not challenged the disciplinary proceeding. In the writ petition.
Why? Because of that, my fact, my lord, that was, my lord, issued, my lord, after 3 years. And my lord, without having any, my lord, the approved
from the concerned authority. My lord, according to the rule, there is a check valve. My lord, why that is in case of a retired.
Give him a copy of the judgment.
Marked it.
And my lord, that if in case of a retired employee, there is a check valve. What is that? My lord, to take the approval from the appropriate authority.
That's again you are going on the merit of the disciplinary proceeding.
Yes, my lord. So, my lord,
then you show me from the prayer of the writ petition, you have challenged on merit.
that was, my lord, when, my lord, after filing of the writ petition, in, my lord, in affidavit in opposition, first time that was in.
Mr. Ghosh, first sustain your case that no review lies.
Yes, my lord. For this,
sustain on that. Then question of if it is reopened, then question of merit.
So, my
no
lord,
merit.
my only submission is that, my lord, that they have been failed to establish any prima facie case that there is, my lord, any apparent error in on the face of the record.
So other than that, no review will lie.
My lord, other point was not urged, my lord.
Other than though that ground, only also review will lie only on the point that error is apparent on the face of record. No other points review will lie.
Yes, my lord.
What are those points?
Other points, my lord, if there was any, my lord, mistake on the part of the advocate.
Look at it. Then, other than go by substantive point. Go by the substantive point. So, this is a substantive point that error is apparent on the face of it.
Yes, fine.
Right? Other than that, is there any other ground, substantive ground?
And my lord, that point of charge sheet, that was also dealt with by your lordship in the impugned judgment also.
Mr. Counsel, we are on review. We are not on merit of the charge sheet.
Yes.
Neither we are on the merit of the disciplinary.
Why I am submitting that? Their cases that was not considered. So it is apparent error on the face of the record. So my submission is that is not at all apparent error on the face of the record, as because that point was already considered by your lordship.
Correct. So other than that, no ground is available for review.
No ground is available.
No ground is available for review. You are sure?
In this case, my lord.
In this case, I am saying.
And my lord, another point, my lord, that is the criminal proceedings.
I'm not.
That was that
argument. That's first you sustain your plea that no review will lie.
Yes, my lord, no review will lie.
Very well. You have taken note of their submissions. You have to deal with it on the next day. Right? Whatever submissions they have made. And I'm saying first you first maintain review and you first dislodge review. I got my answer. Once again, I'm telling both of you.
As regards, my lord, this
15 minutes before I did not get this answer, but the substantive answer I got.
May I submit one thing? If your lordship is
no, I will not.
Already got my lord, your lordship, then
from your submissions, both sides submissions, I got my answer. Where from otherwise I will get? From the air?
No.
একটু খাটতে হবে বাবা, পড়াশোনা করে আসতে হবে।
I have read out the entire thing.
Up to you, sir.
Only may I just conclude?
If you cannot meet that point, don't meet that point.
Just may I just in cuts out, my lord, may I just for my learned friends, buddy, that charge, what has been shown.
Again, you are going to wrong direction.
Just they may answer.
What?
My lord, on this
again, you are going to a wrong direction.
Yes. We shall, my lord, maintain.
First, you sustain your review, and he has to dislodge the review. Yes. Then, question of merit, no merit, that will
come. Only that part next, my lord. Anyway.
Come prepared. You also come prepared.
Yes, yes, ma'am. Very sorry. কোনটা দিলাম তো এই তো
Bring some solid law, both of you. Substantive law.
my reply, my lord, will you please to keep on record, reply to their opposition of section 5 and stay.
How much is the delay? Yes.
Lordship, I do not have any delay, so your lordship will be, since your lordship is entering into the merits of the matter of the review application.
I am absolutely on maintainability of review.
Yes. 162 days, ma'am. To my lord understanding, it is 162 days.
162 days delay. So that I have to hear you first. Ashun. But on the next day, I will hear everything.
Yes, ma'am.
RVW 100. ওটা অর্ডার করেছো, কি ছিল লিখেছো? বলো। Seven and 8 bracket slash school. School. ঠিক আছে, লেখো। Mr. Shagnik Chatterjee has made substantive submissions. Poster. Mr. Shubhi Shanna, senior advocate, has also made his submissions. However, the parties shall make their further submissions on the point of maintainability of the review on the next day. Poster. Mr. Shubhi Sannal, senior advocate, it's a paragraph kintu, sub paragraph. By relying upon the relevant rules from the 2018 rules, submits that the initiation of the disciplinary proceeding is bad and honest in the eye of law. First paragraph. Be that as it may, comma, it is on the merit of the sustainability of the disciplinary proceeding, which can only be gone into if the review succeeds and the writ petition is heard afresh. Poster. Prior thereto, there is no scope for going into the merits of the disciplinary proceeding. Poster. Parties shall resume their submissions on the point of maintainability of review first on the next day. Paragraph. RVW 298 in ray, হ্যাঁ, আর নিচে সবকটা ওই অ্যাপ্লিকেশন গুলো দিয়ে দেবে বাবা, ক্যান কি আছে, ক্যান কি আছে। এবার এর তলায় লেখো ইন রে ক্যান কন্ডোনেশন
my lord, can
1 of
2024
লিখুন। Mr. Shumon De, learned counsel, appears for the review applicant / school submits that there is a delay for about 162 days delay. 162 days. 162 days কথাটা bold in filing the instant review application. Paragraph. Affidavit in opposition has been filed in the condonation application. Full stop. Paragraph. Mr. De files affidavit in reply to the condonation application today in court, which is taken on record.
Along with the stay also. Oh, can do. Very soon.
Full stop. Paragraph. Both these review applications, since both these review applications, acha, na, on the next day, the condonation application first has to be heard in the instant review proceeding.
My lord, if they have no, my lord, an objection, my lord, this condonation may be allowed, we will be, my lord, and arguing on the maintainability part only.
Full stop. আচ্ছা এটা কেটে দাও লেখো so I'm allowing
we have already my lord dealt with the every paragraph of the section 5 application. According to us, my lord, those are not at all any reason, my lord. Anyhow, I'll leave it to your lordship as because, my lord, on the merit of the review, already your lordship heard it.
that I will have
Yes.
here. Full stop. After hearing the part, acha তারপর লেখো since the issue involved in the instant review proceeding is interlinked with the RVW 100 of 2024. And after being satisfied with the explanations given in this condonation application, comma, after hearing the parties, the delay stands condoned, comma, for the ends of justice. First paragraph. The law is also well settled that procedural matter shall not override substantive justice. Accordingly, can
1 of 2024.
Can 1 of 2024 stands allowed subject to payment of cost by the applicant of rupees 2000 in favor of the benevolent fund, comma, Bar Association, comma, High Court, Calcutta. Full stop. Paragraph. On the next day, the applicant shall produce the money receipt showing that the cost has been paid. Full stop. Both the review in the full stop. Since the condonation application has been allowed and the review application has been taken on board, full stop, parties shall first argue on the maintainability of the instant review application.
So, my lord,
as that of full stop.
On my lord, the next day we shall submit that regarding the maintainability.
Just. Full stop. Can ওইটা বলেছি stands allowed subject to payment of cost হয়ে গেছে চলো next. Both the review applications shall appear for analogous hearing on. Give me, but I will complete it.
This week, my lord, any day.
Any day, yes.
আজকে কত তারিখ?
7th August.
আজকে 28
Any day of this week, my lord.
করতে হবে নাহলে পাবো করতে হবে নাহলে কিছু পাবো না
6th August. August 6, 2025.
Any day,
Top, my lord.
Huh? Huh?
6th and 7th, any date apart from 6th and 7th August.
Prior to that,
I do not.
prior to that also.
August 5, 2025.
At the top, my lord.
Under the heading, কিসে আছে এটা? Application, adjourned application. Adjourned application.
No, সোমবার না তো?
এই অমিও এইটা এখানে রেখে দিন। এটা গেঁথে
তার মানে কি ডিআইও আবার
সব
বলবে
সাজিয়ে রেখে দিন। Bring judgments, bring judgments.
Have
You also bring judgments.
we have, my lord, also come with the judgments anyhow.
Huh?
We have already, my lord, come with the judgments, but anyhow on the next day, my lord, we shall serve.
Yes.
We have also.
First on the point of maintainability. First on the point of maintainability.
My lord, this can to affidavit also, my lord, may I file or next day?
Can to for what?
Stay application opposition they have filed, my reply. In RBW 298.
ওই RBW 298 এর নিচে যেটা লিখেছি না, লিখে দাও the petition, the applicant files affidavit in reply in the main review application RBW 298 of 2024,
Stay application.
comma, the same is taken on record. এটা থ্যাংক ইউ। হ্যাঁ, come ready with the judgments.
For orders, item number 27.
You also come, Mr. Ghosh, with all judgments. First you have to, he has to sustain the review, you have to demolish the review. Then.
My lord, 27 and 28, my lord, I am praying for not today. The advocate
for the day.
The third time you have taken time.
Next. If they don't do it tomorrow, remind me. I will send it after some time.
Item number 29.
My lord, I am for the respondent number 4. My lord, this was
Learned advocate Pompati Hubble appearing on behalf of the petition. Learned advocate Pompati Hubble appearing on behalf of the petitioner. My lord,
Passed over for the day.
great.
Item number 30.
Passed over for the day. এই একবার ইয়েকে বাহাদুরকে ডাকো তো, বাহাদুরকে ডাকতে পারো না বাবা, বাহাদুরকে একটু ডাকতে বলুন না, বাহাদুর। Yes.
Motion. Item number 31.
Well, item number 31, I am being led by Mr. Shishano Bandyopadhyay. He is appearing before the Supreme Court today, my lord. I am only praying for not today. Only not today.
Passed over for the day.
Item number 32.
My lord, I am for the state. I am for the investigation.
Passed over for the day.
33, 34, same matter, my lord.
I'm coming in 2 minutes. I'm just coming. Yes, 33, 34. If the petitioner is not there,
Same.
petitioner is not there, passed over. I'm coming. Just coming. Huh?
NBTC, North Bengal State Transport
The
Corporation.
petitioner is not there.
Petitioner no.
report be filed my report already me साथ माला अपना period.
Keep it with you, Mr. Sonatan Paja.
Item number 34, 35, sir.
I'm for the petitioner, 35.
Raining heavily.
Chandri Alam, my lord, appearing. The petitioner before your lordship, my lord, was a
Take the microphone.
petitioner before your lordship, my lord, was a constable under the border security force lordship, and my lord, he was dismissed from service in the year 2013, my lord. My lord, this writ petition on the ground of, my lord, unauthorized absentee, my lord. My lord, this instant writ petition
2013
this writ petition is not, my lord, the issue of the, my lord, dismissal, my lord. This writ petition, my lord, is, my lord, petitioner is praying for compassionate allowance, my lord. My lord, compassionate allowance under section 1441 of 41 of CCS pension rules, my lord, 2021, my lord. This petitioner, my lord, should kindly come to, my lord, the rejection order, my lord, which is at page, my lord, 82 of the petition. My lord, pursuant to the, my lord, previous litigation, my lord, previous writ petition filed by the writ petitioner, my lord, this honorable court, my lord, directed the petitioner to make representation before the authority for praying for, my lord, compassionate allowance. My lord, petitioner made representation, and accordingly, my
Why
lord,
it was rejected? Show me the reasons for rejection.
Rejection order is at page 82, relevant for portion, my lord, at page 86.
Wait.
May I, my lord, at page 86, internal page 5, my lord, at paragraph 6 of the rejection order, my lord, is irrelevant. Petitioner is not entitled for any compassionate allowance as the said rule is not applicable for the petition. Sub-rule 1 of Rule 41 of the CCS Pension Rules 2021 is a government servant who is dismissed or removed from service shall forfeit his pension and gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have been admissible to him if he had retired or superannuation pension. The petitioner absented himself without leave with effect from 25 to 2013, committing a serious offence as per BSF Act 1968. Despite repeated directions time and again to join duty immediately, the petitioner did not join duty and remained absent himself at his own. He has dismissed from service with effect from 30th August 2013. In this case, the petitioner was dismissed on the offence committed by him under section 19A of BSF Act 1968.
What is that offense?
Lordship,
19A, what is the offense?
Lordship, offence is, my lord, he is unauthorized absentee, nothing else. Nothing more, nothing less, my lord. Only ground unauthorized absentee without making any leave application. But though, my lord, my case is petitioner made leave application, he was remain a psychiatric patient, my lord. I have annexed the, my lord, document in support of that, my medical certificate. My lord, that is not, my lord, considered here because my issue of this writ petition, because, my lord, dismissal application, my lord, removal order, my lord, against the order, my lord, we have made, my lord, series of litigation. We have not succeeded.
No, but madam.
May I, lordship, kindly, my lord, may I once place the rule 41(1), lordship, under which, my lord, I am entitled, my lord. Lordship, kindly, my lord, come to, I have annexed the relevant portion 41(1), my lord, at page 89, 90, lordship. Rule 41 says, my lord, compassionate allowance. 41(1). A government servant who is dismissed or removed from service shall forfeit his pension and gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which
So what is the special consideration for you?
while a petitioner under compelling the psychiatric patient, he was under medical treatment, my lord. He was unauthorized absentee. Though his mother, my lord,
That is the, if I hold that, that will affect the disciplinary proceeding. Think of a situation.
no, my lord, this is
Of course.
no, my lord.
Today, if I give the ground for special consideration that he is a psychiatric patient, so he could not attend his duty regularly,
Lordship.
right? Then what remains? That's your defense. And if I give the rubber stamp of High Court, correct, of this court, your defense will automatically sustain in the disciplinary proceeding.
No, my lord.
Of course.
Sir, my lord, these particular, my lord, rule specifies that the compassionate allowance may be given in such a special
So what is the special condition?
psychiatric patient, my lord.
What is your defense? What is your defense in the disciplinary proceeding?
My lord, I have not
What is the defense in your disciplinary proceeding?
similar defense.
Will I now give a rubber stamp?
But I'm not.
Am I not
raising
then,
that.
will I not prejudge the issue?
No, my lord, because my lord, I'm not praying for the my lord the my reappointment or my lord. I'm not praying that. I'm not against the my lord renewal. I have accepted, my lord.
You have accepted the
Dismissal because I have not succeeded before this honorable court, so I have to accept, my lord.
Oh, you have accepted the dismissal.
Lordship, that is why after dismissal, my lord, these compassionate allowance, my lord, come. If those cases, kindly, my lord, allow.
Yes, what do you say?
Lordship, even
if the dismissal is accepted, then what do you say?
Lordship, it's if the dismissal is accepted, Lordship.
Take the microphone, madam.
Lordships, kindly come to page 90, Lordship.
90.
Lordship, dismissal was in, if your Lordship sees that compassionate allowance, first part is he who is dismissed or removed from service shall forfeit his pension or gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have, Lordship, Lordship, let us read further, Lordship. I shall come to
special
nothing, Lordship.
The expression is it defined anywhere?
It is
What are
not
the
defined,
special
but Lordship, let us come to the next paragraph. Competent authority shall either on its own or after taking into consideration the representation of the government servant. So the special consideration, it can be the competent authority can do it on its own or on the representation. If any, and examine whether any compassionate allowance is to be granted and take a decision in this in accordance with the proviso of sub-rule 1, not later than 3 months after the date of issue of the order of penalty. Lordship, order of penalty is way back in 2006, I think, Lordship, subject to correction. So it is, I mean, at that point of time, we did not suo motu do it, neither did he give any application. The first application comes up in 2024, pursuant to the order of this court. So, because Lordship, once a compensatory allowance is given, a PPO is issued. So it goes through the formality of a pension, the money is restricted, whatever it is. So the requirement is the competent authority is to come to under special consideration suo motu give or an application.
No,
and the
but
time
here,
limit
here the competent authority has come
not given. Then
no, he has come. It has come to a finding not to give.
Yes, it has come to a finding not to give pursuant to the order of this court. Prior to that, there was no application for compensatory allowance.
That's all right.
So
So let us take it from the date of the order of this coordinate bench.
2024.
Coordinate bench order was
Passed in the passed last year, Lordship, 2024, subject to correction. Okay, I'll just check, Lordship. That is 2024, 19 June 2024. And he was
Thereafter, petitioner made
Lordship.
representation.
show me that order.
At page 79, Lordship.
I think he was dismissed in 2013, subject to correction. 2013, no? Dismissal? Dismissal was 2013, Lordship. So throughout from 2013 to 2024, Lordship, the order
did not apply.
No. The order of the High Court is at page 17, Lordship. The High Court gives him the option to apply. Then on the basis of that application in 2024, Lordship, we considered the entire matter because Lordship, now your Lordship comes to page 91, I think.
Now, Madam, kindly come to sub-rule 2241. Read.
Yes, that is
Sub-rule 2 to rule 41.
sub-rule.
Page 90.
Lordship.
Read.
Lordship. Competent authority shall either on its own or Lordship. But Lordship, they have not taken this point in their rejection order, my Lord. They have neither taken
No,
this
no,
point
I'm not on that.
delayed.
Not on that, not on that. Kindly read.
The competent authority shall either on its own or after taking into consideration the representation of the government servant, if any, examine whether any compassionate allowance is to be granted and take a decision in this regard in accordance with the proviso to sub-rule 1, not later than 3 months after the date of issue of the order imposing the penalty.
All right.
Lordship, kindly, my Lord, Lordship, the competent, sub-rule 3, the competent authority shall consider each case of dismissal and removal from service on its merit to decide whether the case deserves of special consideration for sanction of compassionate allowance, and if so, the quantum thereof. Then, my Lord, clause B, the actual misconduct which occasioned the penalty of dismissal or removal from service and the kind of service rendered by the government servant. In exceptional circumstances, factors like family members dependent on the government servants, along with other relevant factors, where an order imposing the penalty of dismissal or removal from service was issued before the date of commencement of these rules, at the time did not examine or decide whether or not any compassionate allowances was to be granted. In that case, the authority shall take a decision in this regard not later than 6 months.
That is also good.
Lordship. The compassionate shall, after aforesaid period of to a servant on whom a penalty, dismissal, or removal from service was imposed before the date of commencement.
So now I'm asking you two
Lordship,
questions.
Lordship, may I humbly, my Lord? My Lord, the writ petitioner's application, my Lord, writ petitioner's application for granting compassionate allowance, my Lord, they have never, my Lord, whispered my Lord, anything regarding the delayed, my Lord, representation. Now, my learned senior friend is submitting that the ground of delay, my Lord, they have rejected.
Achha, now my questions to you.
Lordship.
Dismissal in 2013.
Lordship.
Admittedly, within 3 months, they have not taken any steps.
No.
You filed the writ petition in 2023, after 10 years.
No, my Lord. Before that, my Lord, in between there are series of litigation against, my Lord, the rejection.
That's challenging
removal.
the challenging disciplinary proceeding.
Disciplinary proceeding, removal.
Forget it.
Lordship.
So claiming compassionate alliance, for the first time you raised your claim in 2023.
2023. Lordship.
After 10 years
Lordship.
of dismissal.
Lordship.
High Court allowed you, coordinate bench allowed your consideration, a claim to be considered.
Pursuant to that order, I made representation.
Very well. It was considered. And the order of dismissal came. Order of rejection came.
Rejection.
6th of August 24. Order of rejection came. 6th of August 24. Then on 18th September 24, you filed this writ petition.
Lordship.
The rule 41 sub rule 2 says outer limit of 3 months.
Lordship.
The moment outer limit of 3 months had elapsed in 2013, they have not done anything. After 10 years, you filed a writ petition. So your cause of action had already given once a life. A life was given,
Lordship.
right?
Listen to that strength, my lord.
Some oxygen was supplied.
Lordship.
You were sent to ventilation. Your client was sent for ventilation, right?
Lordship.
Now the ventilation fails.
Ventilation fails, but my lord, subject to correction of your lordship, rule
Sir,
says
madam, if I pass another order, it would amount to elongation of the period.
no, my lord, may I, my lord? My lord, these rule
In applying equity, it cannot be done. It has already been done once by the coordinate bench.
Lordship, that is, my lord, in respect of making representation, my lord.
That's all.
Lordship, no, my lord, but they have rejected the representations. Therefore, my lord, I am before your lordship.
Yes, they have
because
rejected.
the special consideration have not been taken into consideration.
Special consideration is their discretion. It
No,
is
my
their
lord,
discretion.
Kindly, my lord, may I humbly, my lord, submit, my lord, one judgment of Supreme Court, my lord, on this.
And that too, a special consideration has to be considered in the light of the fact how vigilant you were.
No,
How vigilant you were.
Kindly, my lord, seize once, my lord. Citation also. 2014 SCC 11, page 684.
Yes.
Lordship, kindly, my lord, come to kindly, my lord, lordship, come to relevant portion, my lord, paragraph 13 onwards. We are of the considered view that the adjudication by the courts below with reference to Rule 41 of the pension rule is clearly misdirected. The rule itself contemplates payment of compassionate allowance to an employee who has been dismissed or removed from service. Under the punishment rules, the above punishments are of the severest magnitude. These punishments can be inflicted only for an act of extreme wrongdoing. It is an account of such wrongdoing that the employee concerned has already been subjected to the severest from the form of punishment, sometimes even for being incorrigible. Despite that, the rule contemplates sanction of a compassionate allowance of up to 2/3 of the pension or gratuity or both, which would have been drawn by the punished employee if he had retired on compassionate pension. The entire consideration up to the present juncture by the court below is directly or indirectly aimed at determining whether the delinquency committed by the appellant was sufficient and appropriate for the infliction of the punishment or dismissal from service. This determination is relevant for examining the veracity of the punishment order itself. That, however, is not the scope of the exercise contemplated in the present consideration. Insofar as the determination of the admissibility of the benefits contemplated under Rule 41 of the pension rule is concerned, the same has to be by accepting accepting that the delinquency committed by the punished employee was of a magnitude which is sufficient for the imposition of most severe punishment. As in the present case, unauthorized and willful absence of the appellant for a period of 320 days has resulted in the passing of the order of dismissal from service. The punishment inflicted on the appellant has been found to be legitimate and genuine, as also commensurate to the delinquency of the appellant. The issue now is the evaluation of claim of the punished employee under Rule 41 of the pension rule. In our considered view, the determination of a claim based under Rule 41 of the pension rule will necessarily have to be saved through an evaluation based on a series of distinct considerations, some of which are illustratively being expressed hereunder. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act of moral turpitude? An act of moral turpitude is an act which has an inherent quality of baseness, vileness, or depravity of with respect to a concerned person's duty towards another or to the society in general. In criminal law, the phrase is used generally to describe a conduct which is contrary to community standards of justice, honesty, and good morals. Any debauched, degenerate, or evil behavior would fall in this classification. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act of dishonesty towards his punishment, towards his employer? Such an action of dishonesty would emerge from a behavior which is untrustworthy, deceitful, and insincere, resulting in prejudice to the interest of employer. This could emerge from an unscrupulous, untrustworthy, and crooked behavior which aims at cheating the employer. Such an act may or may not be aimed at personal gains. It may be aimed at benefiting a third party to the prejudice of the employer. Was the act of delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act designed or personal gains from the employer? These would involve act of corruption, fraud, or personal profiting through impossible means by misusing the responsibility bestowed in an employee. By an act may or may not be aimed at causing loss to the employer. The benefit of the delinquent could be at the peril and prejudice of a third party. Was the act of delinquent which resulted in the infliction of the punishment or dismissal of or removal from service aimed at deliberately harming a third party interest? Situations hereunder would emerge out of act of deserving.
Why will you not go before Central Administrative Tribunal?
No, my lord. BSF, my lord.
Oh, BSF.
BSF. So, my lord, these are the points, my lord. May I, my lord?
But here, your judgment in the Supreme Court judgment, the petitioner applied before Central Administrative Tribunal.
Yes, because he is. Maybe the my lord, the issue, my lord, the main issues, my lord, the for consideration of the my lord, the compassionate allowance, these points are to be considered, which they have not, my lord.
No, but this judgment shows that actions were taken by the petitioner contemporaneously.
My lord, kindly, my lord, see paragraph 17, my lord.
But here, petitioner waited for 10 years.
That is not
in
the
filing the
subject to
writ
correction.
petition.
Lordship, my lord, that is not the issue, my lord. I am, my lord, praising, my lord, that they have not considered properly, my lord. Compassionate allowance should be, my lord, considered properly in terms of the, my lord, section 41, where, my lord, these Supreme Court, my lord, Honorable Supreme Court judgment categorically explained, my lord, that the delinquent, my lord, the employee concerned, my lord, throughout his entire service period, served without any blemish remark, my lord, and thereafter, due to unauthorized absentee, my lord, he has removed. Whether the unauthorized absentee, my lord, amounts to any gross misconduct, like, my lord, these are the main criteria, my lord. These are the main, my respectful understanding, my lord, subject to correction, my lord. And they have not, my lord, even whispered a single word, my lord, in this regard. Paragraph 17 of this judgment, my lord, the Supreme Court says we shall only endeavor to delineate for a few of the considerations which ought to have been considered in the present case of determining whether or not the appellant was entitled to compassionate allowance under Rule 41. In this behalf, it may be noticed that the appellant had rendered about 24 years of service prior to his dismissal from service by order Derato. During the above tenure, he was granted 34 good entries, including 2 commendation rolls awarded by the commissioner, etc., my lord. None of the authorities of the administrative side, not even the tribunal or the High Court, applied the above parameters to determine the claim of the appellant for a compassionate allowance. We are of the view that the consideration of the appellant's order of dismissal, appellant's order of dismissal, and also whether the delay by
Why does it say your rejection order? Why does it say that the rule is not applicable for the petitioner?
That is my question, my lord. They have not
Madam,
elaborated any reason,
why
my
it
lord.
is said so?
Reject.
Paragraph 6, page 5, running page 86.
Lordship, I'll just check.
86, paragraph 6.
Paragraph 6, page 5.
No, 86.
Internal
Oh, page 86.
Internal page 5.
Read paragraph 6.
The petitioner is not entitled, Lordship, this paragraph, for any compassionate allowance, as the rule is not applicable to this petition.
Why?
Lordship, I shall pausing here for a moment. If your lordships come to page 91.
91.
Subrule 4 says, where an order imposing the penalty, dismissal, or removal of service was issued before the date of commencement of these rules, the competent authority at that time did not examine or decide whether a compassionate allowance was to be granted in that case. The authority shall take a decision in regard not later than 6 months from the date of commencement of these rules. Next rule. No compassionate allowance shall be sanctioned after the expiry of the aforesaid period of 6 months to a government service on whom a government servant, on whom a penalty of dismissal or removal from service was imposed before the date of commencement of these rules. Therefore, Lordship, the time factor is a very important factor. So that's why they have said that the rules are not applicable. And Lordship, this is where we cannot now.
Lordship, the first page of this impugned order of rejection, my lord,
that was pursuant to the orders of this honorable court. So that we have to consider.
No, that's all right. But the thing,
my lord, since they have, my lord, passed this reasoned order pursuant to the honorable court's order, which have been passed in the year 2024, they cannot, my lord, take this point that within 3 months or within.
Of course they can.
My lord,
The order is consideration. Come to the coordinate bench direction.
Yes, consideration, my lord.
Consideration means they are open. They are open in every respect.
But admittedly, my lord, the petitioner, by pursuant to that order of 2024 passed by a coordinate bench, admittedly, my lord, on 2024, my lord, after passing the order, making the application.
Absolutely, absolutely. Kindly show me the order of the coordinate bench.
79,
Absolutely.
79, lordship.
No doubt about it.
'79, lordship. On behalf of the respondent, my lord, third paragraph. Respondent, it is submitted that the petitioner has not yet applied for compassionate allowance.
Right. So
Lordship.
court just granted you liberty to apply and consideration.
So
That does not mean the statutory rule will be given a go by.
Lordship, but my lord, it is admitted that after this order I have applied. my lord.
Absolutely, but your time shall not start from that date. Time starts under the statutory rule. It was it was again a compassionate approach taken by the court. But that does not give you a right. Whatever statutory rule is there, rule is there. You have to abide by it.
And my lord, regard to my lord misconduct, my lord, those points, my lord.
That's a disciplinary proceeding.
They have not.
No, madam. No.
They have not, my lord, even whisper any point, my lord. My lord, only on the ground of time, my lord, it is admitted that, my lord, I cannot improve my record, my case, my lord, that I have made application prior to this 2024 order. Subject to this order, my lord, I have made application.
Absolutely. Had that order not been passed,
So it is. So it
had you, that order will not create any right. That coordinate bench order will not create any right overriding the statute.
But my lord, kindly come to their rejection order, my lord.
Yes.
Or rules itself, my lord.
That will not give you a overriding effect on the statute. No.
My lord, the competent authority, rule 41 subclause 2, my lord, the competent authority shall either on its own or after taking into neither their own, my lord, they have
not done their own.
Not done,
Then
my
you
lord.
approach after 10 years. It was a mercy shown to your client, and very well you apply, they will consider.
But they have to consider properly, my lord. This is my only submission. They have taken into, if they have taken, my lord, all the points, my lord, as stipulates in the, my lord, Supreme Court judgment, my lord, they have not, I have no grievance. If after consideration of that points, my lord, my application rejected, I have no grievance, my lord. But they have they have not taken into consideration at all any points, my lord. Simply saying misconduct. Lordship, kindly come to paragraph 7 of their last.
Naturally.
My lord, misconduct means, my lord, not unauthorized absentee, which is categorically stated in the Supreme Court judgment.
That is not the issue to be decided in this writ petition. Because you have accepted dismissal.
Yes, I am not, my lord, alleging the removal or dismissal, my lord. I am praying, my lord, for the purpose of, my lord, determining the compassionate allowance, my lord, they have to, my lord, deal with the proper form, deal with proper form of misconduct, my lord. What type of misconduct I have made, my lord?
No, madam.
Rules
Kindly come to compassionate allowance. Rule 11, Rule 41. A government servant who is dismissed or removed from service shall forfeit his pension and gratuity.
Lordship.
Provided that the authority competent to dismiss, provided the authority competent dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance.
Lordship.
So that special consideration, they thought it fit not. Kindly see why.
Lordship.
Kindly come to paragraph 7 of dismissal. Rejection order.
Yes, ma'am.
That's the reason
Yes.
why they will not go for special consideration. Read on loudly.
Since the petitioner committed misconduct which is against the norms of a disciplined force like BSF, the petitioner is not eligible for compassionate allowance.
That's sufficient.
Misconduct.
Discipline, yes.
But Lordship, kindly come once, my lord, once more Supreme Court judgment, my lord. Lordship, kindly comes.
That's sufficient.
My lord, paragraph 14, my lord, which categorically says Roman 1, Roman 2, Roman 3, Roman 4, Roman 5, Roman 6, my lord, which is the misconduct. These points to be treated as misconduct, which the petitioner is, my lord, did not fall under this category, my lord. Lordship, kindly.
No, but the moment you are accepting the dismissal, you have accepted the ground of misconduct on which it was done.
Unauthorized unauthorized absentee.
That
These
matter
unauthorized,
ends.
Lordship, these unauthorized absentee does not fall under these category, Lordship.
Madam, the moment you accept dismissal, so the ground of dismissal you also accept.
I'm not against the dismissal, my lord. But
The ground of dismissal was unauthorized absence.
Lordship.
The moment you accept dismissal, you accept the ground of dismissal. That's the reasons for dismissals are also admitted by you.
Unauthorized absentee.
That's
that
admitted
ground
by
I
you.
have accepted, my lord. I am not against that ground. I am more on that ground, my lord. I am also, my lord, referring that ground because, my lord, the unauthorized absentee does not fall under the misconduct in this Supreme Court judgment.
Then your dismissal will go. Ought to have been challenged on that ground. You have not challenged that. You have not challenged your dismissal. The moment you have not, suppose you are evicted by your landlord on the ground of default. You accept the eviction. What does it mean? What does it mean, madam?
On the ground of default, I have accepted my eviction.
That's
but not
the only,
other ground, my lord.
No, that's
Not-
right.
not-
So the only ground of eviction is default. Only ground.
Ground of default.
Right.
That is I am on, my lord.
Right.
My only ground.
Right. The moment only ground for default, only ground for eviction is default, and you accept the eviction, which means you accept the ground for eviction default.
But this is the same issue, my lord, before the Honorable Supreme Court. The same issue, unauthorized absentee. The issue is
I
same, my
accept, but there the disciplinary proceeding was challenged. There the
lord. And fails, like the petitioner.
Huh?
In this matter, in this Honorable Supreme Court judgment, my lord, like the petitioner, dismissal proceedings have been challenged and fails. Like petitioner, I have also challenged, my lord, and fails. Thereafter comes the, my lord, provision of compensation allowance. Lordship, kindly consider once.
Let's see.
My lord, head note, my lord, head note says so that.
Head note is not important. Kindly read paragraph 3, then kindly come to that you were dismissed, you applied before the petitioner there, applied before Central Administrative Tribunal,
Lordship.
appeal carried, appeal also upheld against, appeal also went against the petitioner. Petitioner proceeded before Central Administrative Tribunal. It also arrived at a finding not to interfere with the order of dismissal. Dissatisfied with the same, the appellant filed the writ petition before High Court. Appellant, however, withdrew the aforesaid writ petition with liberty to seek compassionate allowance. The above order dated after is being extracted. Learned counsel for the petition on instruction prays for withdrawal of this because the petitioner wants to take some appropriate remedy for grant of compassionate appointment. Dismissed with liberty, petitioner to seek appointment. Compassionate appointment. Appropriate remedy for grant of allowance.
dismissed with liberty to the petitioner to seek appropriate remedy for grant of allowance.
Right. Then
Then the appellant moved the representation, same here, my lord, and thereafter compassionate allowance, my lord, section 41. Paragraph 8, lordship, with this background, if the
tribunal also rejected.
okay. Paragraph 15, lordship, once, my lord.
you consider this judgment and come back.
Paragraph 18 says, my lord, the claim of the petitioner, my lord, completely misdirected, my lord.
Not claim,
Not claim,
consideration.
Lordship,
It was misdirected. This is actually my submission, my lord.
I'll come back, Lordship. Then.
You come back. If necessary, I will set aside that and I will send it for reconsideration in the light of this Supreme Court judgment.
I'll come back.
Lordship,
If you first you consider,
Let me consider, Lordship.
if necessary.
Yes.
Otherwise, I will afford. Let's see. Ashu.
affidavit service.
Affidavit of service filed in court today is taken on record. Ms. Sujata Mukherjee, learned advocate, appears for the petitioner. Ms. Chandrei Alam, learned counsel, appears for the Union of India. Stroke respondents. Paragraph. The petitioner is a dismissed constable from the
BSF.
Border Security
Security
Force. Bracket BSF. The petitioner has accepted the dismissal and then claims compassionate allowance in terms of Rule 41.
41 subsection 1.
In terms of Rule 41 of the
TCS pension rules 2021.
No.
CCS pension rules. CCS pension rules.
21.
Now it's 20.
Now it's 2021.
2021. This is your annexed. What you have annexed?
Everything is there. Then the
37 amendment has been. বাদবাকি সব একই তো আছে।
Full stop. Paragraph. In support, learned counsel for the petitioner has relied upon a decision of the Honorable Supreme Court in the matter of ETA versus ETA reported at ETA. লিখে দিন। যেভাবে আমি লিখি, হ্যাঁ, in the matter of করে bold italics. এইটা না আমার চেম্বারে নিয়ে যেত। Paragraph. Ms. Chandrei Alam has prayed for some time so that she can consider the ruling of the Honorable Supreme Court and revert back to this court.
Lordship.
And revert back and make her submissions. Paragraph. The writ petition shall appear under the heading কিসে আছে?
Motion.
For orders.
For orders.
Or
No.
for orders.
Is it taken up every day or like okay? Any for orders?
For orders on আজকে কত? August 5.
August 5.
2025.
Deep.
ওটা বন্ধ করবো। Two matters today. I was